That is the Lordship. Lordship, I get to mention item number 23, my Lord. Lordship, today I would have got some answer difficulty, my Lord. Matter will be next week, my Lord.
Yes. What is the prayer?
Next week, my Lord.
Why?
Today we have got some parcel difficulty, my Lord.
Okay. Heard. Mr.
Game over.
A. Mubarak, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. Considering the ground, the prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
May I please, Your Lordship? I'd like to mention item number 8, Your Lordship. Lordship, this matter may kindly be taken up on Monday. My senior is there, Ashish Sancheta.
Okay. Place this matter before any other bench without me, within bracket my name, on Monday.
Deeply, Your Lordship.
May it please, Your Lordship, I beg to mention item number 15, Your Lordship. Due to personal difficulty, Mr. J.M. Sahiwala, Senior Counsel,
50.
15, Your Lordship, will not be able to appear today.
Heard Miss A. K. Sharma, learned counsel for the
Petitioner, Your Lordship.
applicant, who prays for an adjournment due to personal difficulty of the conducting counsel for the applicant. The prayer is allowed.
Your Lordship, there is an interim.
The interim order shall continue till next week.
It may be fixed.
No. No date. Seeking adjournment and praying for dates. Who benefits you will know. Either you. Yes.
Please, Your Lordship, I have a two RSI matter, Lordship. Kindly restate this matter next week on any convenient day, Lordship. The
Okay.
2016 and 19 matter. Or
At what stage?
here it stays, Lordship.
Hearing you have to pray before registry. If it is an all pending matter, if you want expeditious hearing, you may file interrogatory applications. Pray before registry.
May I please, Lordship, with consent of the applicant, Lordship, I beg to mention item number 24, Lordship. I'm on behalf of Caveator, Lordship. There is some personal difficulty on the conducting counsel on behalf of Caveator. So kindly adjourn for today, Lordship.
You have informed the other side?
Yes, Lordship.
I'm for the appellant.
Appellant is present. Lordship.
Okay. Heard Mr. M. Das, learned counsel for the appellant. Also heard Mr.
P. Sharma on behalf
B.
of
Sharma, appearing for Mr. M. K. Jain, learned counsel for the caveator, who prays for an adjournment on the ground that the engaged counsel for the caveator has some personal difficulty today. Learned counsel for the appellant does not raise any objection to the said prayer. Hence, the prayer is allowed.
kindly fix on next week, Lordship. 26, if possible, Lordship. Day.
Wednesday, Lord.
Let this matter be listed in the next week on a date to be fixed by registry.
Obliged.
Please, Your Lordship. Also, I beg to mention item number 14, 1.
Yes.
Lordship, this matter may be adjourned for the day, Lordship, as Senior Counsel is out of station, Lordship. I've already taken the consent from the petitioner, Lord.
Heard Miss M. Nirola. Then you are appearing for respondent number 8, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. She submits that she has informed the learned counsel for the petitioner, who does not have any objection to the prayer for adjournment. Hence, the prayer is allowed. Let this matter be listed in the second week of December on a date to be fixed by registry.
May I please, Your Lordship? Your Lordship, I have mention for listing when RFI connected with IA, connected with an RFI, for any hearing, Lordship. Yesterday, I have mentioned, but I mentioned in return, Lordship. There are certain developments have occurred. We have received a notice under section 13(2) of
Tuesday.
service here.
Tuesday.
Tuesday. Much obliged, Lordship.
It please your lordship, I have another prayer for listing of a MSc appeal lordship. This matter is in the stage of hearing lordship. The last list is on 14/10 lordship, 2025. May I pray for next week lordship?
No, next week is not possible.
For-
Okay, second week of December.
Lordship, I beg to mention a listing for CRPIO on the first week of December, Lordship.
Okay.
Bless Lordship.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 31 and 33. My lord, we have recently received the brief. Today we're filing our Wakalat Nama, my lord. Matter may be listed after 2 weeks.
Therefore,
Respondent, my lord,
heard Mr.
M. Sharma.
M. Sharma.
Your lordship, for the petitioner, the interim order may continue.
Also heard Mr.
I'm Kashyap.
M. Kashyap. Learned counsel for the petitioners. Learned counsel for the Mr. M. Sharma. What is your name?
M. Sharma.
Mr. M. Sharma, learned counsel submits that he has been instructed to appear in this case for the respondent side, and he would be filing his Wakalatnama very soon.
Today itself, my lord.
He will be filing his Wakalatnama during the course of the day. And he prays for an adjournment so that he may go through the brief. The prayer is not opposed to by the counsel for the petitioner. Hence the same is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry. The interim order shall continue till next date.
May I please? Okay, I'm praying for listing of a MSc appeal on next Wednesday.
Or,
Admission.
okay,
May I please, Lord? Because I'm praying for listing of a IA lordship. Any as for lordships convenient, because this matter was not listed, so I'm for the
I
PML.
regarding
It's for condonation of delay lordship. The appeal is filed by the insurance company.
first week of December. Okay,
May I please, Lord? Okay, back to mention item number 46 lordship, with the consent of the other side lordship. Lordship, we have received the judgment copies now, lordship. And lordship, we have to go through the judgments and we will we will file our judgment lordship. Lordship on Tuesday. lordship.
46.
46 lordship.
46 is only a transfer petition.
Yes, lordship, it was in. Lordship, we have received the judgments lordship. Now we have to again submit some lordship after going through these judgments lordship. The family court matter is fixed on 26 lordship.
Okay,
On 25th lordship.
heard Mr. What?
even-
A. Mena, learned counsel for the
petition.
petitioner, who prays for an adjournment on the ground that he has to go through some authorities on which he is relying before he places the same before the court. And stop, also Miss S. Parveen, learned counsel for the respondent, who does not oppose the prayer. The prayer is allowed when?
25th lordship. 26th is the Lord date.
26th, the date fixed in the family court. 25th, lordship.
Let
Tuesday.
this matter be listed on 25th of November.
Obliged, lordship.
Let me apologize, your lordship. With regards to the mention item number 15, your lordship, allow, at least mention the week, your lordship, allow. Third week of December, your lordship.
Item number 15, what was directed? Okay, let this matter be listed in the third week of this December on a date to be fixed by registry.
My lord, I beg to mention a CRPIO to be listed, my lord. On the first week of December, my lord.
Okay.
Deeply open.
I think one for withdrawal.
May I please lordship? The applicant instructed us to withdraw the matter as he is not willing to proceed the case.
My lord, I appear for respondent number 1 to 4, my lord. My name may be reflected in the order.
Heard. What is your name?
Partner, on behalf of DK Das.
Heard Miss M. Katunia, appearing on behalf of Mr. D.K. Das, learned counsel for the appellant. Also heard Miss A. Bhattacharya, learned counsel for respondent number
1 to
1 to 4. Learned counsel for the appellant submits that he has been instructed by the appellant to withdraw this appeal as the appellant is not interested to pursue the matter. Learned counsel for the respondent raises no objection to the prayer. Hence, the prayer is allowed. This appeal is dismissed on withdrawal.
Lordship regular bail application. Lordship earlier, my lord, this petitioner earlier order may be seen at page, my lord, 26. My lord, today 112 days of his custody, and the matter is charge sheeted. Charges also framed, my lord. In the learned court below has rejected my bail prayer. That is page 29. Charges framed on 13th and 2025, my lord, page 31. So that this is LCR, scan copy of LCR and notice.
Notice to go, my lord, POXO matter, my lord.
Oxometer.
Yes, my lord.
Heard Mr. I. Learned counsel for the petitioner. Also heard Mr. K. Bashaw, learned additional public prosecutor. Since this matter involves offense under POXO Act, let the notice be issued to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on 17th of December. Let the scanned copy of the trial court records as well as the scanned copy of the connected case diary be called for list accordingly.
Obliged.
Lordship may kindly please call for case diary.
We'll produce case diary, Lordship.
Heard, Mr. What is your name?
Oliullah.
D. What is your name?
Oliullah. Ullah.
Oh, Mr. Ola, learned counsel for the petitioner. Also Miss
R. Hussain, your Lordship.
R. Hussain, learned counsel for NCB. Let the case diary be called for. When? Let this matter be listed on 5th of December. Bail hearing we will take.
My lord, here, my lord, this case, my lord. Otherwise, my lord, can take, my lord, this is also POXO matter, my lord. There's a notice is awaited and same time, my lord, the scan PCR we are not receiving. My lord.
Notice has been received.
Yes, my lord, notice. my
Notice
lord,
has been served.
My lord, that a report, my lord, we don't have, my lord. We have to take the, my lord, instruction, my lord.
No one has appeared for the petitioner on call. The Mr. K. Bashaw, learned additional public prosecutor, submits that some time may be granted to the prosecution side so that fate of the notice issued to respondent number 2 can be reported to this court after taking necessary instructions from the officer in charge of the concerned police station. So it also appears from the office note dated 7/11/2025 that the scanned copy of the trial court records have also not been received. Let the reminder be issued for the scanned copies of the trial court records. Let this matter be listed on 12th of December.
Okay.
Item 4.
May please, Your Lord. Application filed by the petitioner in respect of a matrimonial matter filed by the husband at Guwahati. Whereas the petitioner is the original place of residence is Udalguri. And she is there for last 5 months, since 14/6/2025. She
Whether Guwahati court has jurisdiction, whether you stayed at Guwahati together,
once we stayed together,
where did you last stay together?
last I've been there in the my paternal house since 14/6/2028, because there are a lot of tortures meted out to me, for which under such compelling
No,
circumstances.
where you stayed together with your husband for the last time?
Last time at Guwahati.
Guwahati, okay.
At Bangalore also to some, for a brief period.
No, where you last stayed?
Last Bangalore. After Bangalore we came, he has dropped me at my paternal home and he came to Guwahati. Husband.
And where, so whether Guwahati court has jurisdiction?
Guwahati court has jurisdiction.
How?
Because after marriage, he brought her to at Guwahati.
Okay, then why are you filing transfer petition?
Because I am residing there, Lordship. And already a DV case is pending against the husband.
Where?
Udalguri, Your Lordship. That I have already annexed, Your Lordship. Kindly.
DVK, which case was filed earlier?
Earlier, this family court matters.
Thereafter you filed the
Prior
DVK.
to that, I filed an FIR. I was supposed to file this DB case, and knowing that I am going to file this application.
When is the next date fixed in the family court?
8/1.
8,
8/1/2026.
okay. Heard Mr. N. Sharma, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure, 1908, has been filed by the petitioner Srimati Sanghamitra Barwa, praying for transfer of FC within bracket civil case number 974/2025 from the Court of London, Principal Judge, Family Court number 1, Kamrup Metro, to the Court of District Judge, Udalguri. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents by speed post within 7 days from the date of this order, returnable on 18th of December, list accordingly.
In the meantime, also further proceeding.
Further proceeding is fixed after that date. It is fixed on January. There will be no proceeding in between. In between, there will be no.
If the matter is listed after 8/1, then it will be difficult because I had to come alone. I'm a lady, so I had to come alone.
No, we are fixing this matter before that day. We are fixing this matter on 18th,
18 December.
18 December.
Deeply.
My lord, I beg to apologize, my lord. In my lord, there is the bail hearing matter, my lord, earlier, item number 21, my lord. My lord, the petitioner did not even take the steps, my lord. I made this mistake, my lord. In office note, it is reflect, my lord.
Then we'll call it after some time.
Yes, my lord, that will be better, my lord.
Eh,
Because, my lord, they didn't take the steps, my lord.
continue. When the matter is called
Yes,
up,
yes, my lord, yes, my lord.
in its due
Because,
turn.
my lord, they didn't take the step. I wrongly, my lord.
Okay, okay.
Thank you, the lordship. Transfer petition lordship transfer the title suit for resolution of marriage from Golaghat to lordship Tinsukia. The respondent was residing in Golaghat, but the petitioner was compelled to leave her matrimonial house, and the petitioner is staying with her parents along with her minor son in Tinsukia Makum lordship. And the
Where you last resided with your husband?
lordship is Bokaz, and because lordship the husband was a government employee, and because of the transfer lordship I have
What is the stage of the suit?
Except it is 5711 lordship. Because it's a too far.
Miss. What are the grounds?
Come source and stay with her old age parents along with her minor son, and it take lordship 5 to 6 hours to come to Golaghat from Tinsukia lordship.
Miss M. Nirola, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner Srimati Vijay Lakshmi Gupta, praying for transfer of the title suit number within bracket M 7/2025 pending before the Court of London, Additional District Judge Golaghat, to the Court of Competent Jurisdiction at Tinsukia. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post within 7 days from the date of this order, returnable after 4 weeks. You have prayed for interim. Considering the grounds stated in the petition, the further proceeding of title suit within bracket M number 7/2024 shall remain stayed till next returnable date. Next returnable date mention kore dio. 8th of January.
Please, Lordship, my lord, file this petition file under 227 of the Constitution. My lord. By this petition, my lord, the order dated 30 January 2023 has been under silence, my lord.
23.
30 January 2023, my lord, page 31, annex 3, my lord. There is an order passed by my lord, land grabbing tribunal, my lord.
Where is the impugned order?
My lord,
Page?
page 31, annex 3, my lord. The party portion is page 45.
This order is a appealable order.
My lord, But as there is no tribunal has been, appellate tribunal has been constituted, my lord, that's why earlier I have approached the number by under 226, my lord. The coordinate bench
No,
is of
but,
the opinion.
but now appellate tribunal has been constituted or not,
No, my lord.
till now?
Till now, my lord, as per my knowledge goes, my lord.
Yes.
My lord. Earlier, my lord, I have approached the honorable court by writ petition, my lord. That was, my lord, the impugn order has been stayed, my lord. Thereafter, my lord, the coordinate bench is the opinion that, my lord, the petitioner does not lie, you have to come under 227, my lord. Thereafter, my lord, this petition will file, my lord, after.
Where is the order of the,
Lordship may come to my lord. Page 72. The order, then the stay order is my lord. Page 74. Then thereafter, my lord, the last order of the writ petition, my lord, is page 78.
not Mr. M. Sarunia, learned counsel for the petitioner. This application under Article 7 of the Constitution of India has been filed by the petitioners impugning the judgment of the special tribunal within bracket land grabbing Walpara in land grabbing case number 30/2014. Whereby you were directed to hand over possession, whereby the present petitioners wherein the present petitioners were found to be the land grabbers, and the respondents were directed to be put in possession of the scheduled land. Now, who is in possession?
I'm in position, my lord. We are in position, my lord. Because it's my forefathers.
When the counsel for the petitioner submits that on an earlier occasion, the petitioners had approached this court by filing a writ petition, which was registered as WPC
2206, 2020.
WPC number 2206/2023, whereby initially by order dated 28/4/2023, the notice was issued to the respondents, and the respondents were directed to maintain status quo in respect of the scheduled land. However, later on, by order dated 12/8/2024, a coordinate bench of this court held that the writ petition was not maintainable. Accordingly, the petitioners were allowed to withdraw the writ petition with liberty to file an application under Article 227 of Constitution of India. And therefore, the petitioners are before this court. Issue notice to the respondents. The petitioners shall take steps for issuance of notice upon the respondents by speed post within 7 days from the speed post, as well as by usual mode within 7 days from the date of this order. Returnable after 4 weeks. Till returnable date. Stop considering that on earlier, okay. Learned counsel for the petitioner has submitted that the petitioners are in possession of the land which is their ancestral land, and they have a good case in this revision petition. Hence, till the next returnable days, status quo in respect of the scheduled land shall be maintained.
Right.
List accordingly.
Valuable.
May please, your lordship. The dismissal of my land grabbing case is the subject matter of this CRC, lord. The lordship may kindly take a page 42 for a moment. Lord. Page 42, lordship.
Where is the impugn order?
Impugn order is at page 200. Lord. The impugn order, lord, is factually incorrect, lordship. I'm sorry, it's lord 200. 220, lordship, page number 220, lordship. May I read, lord?
No. What was ordered? By
Lordship,
it is against some application. 220. Page number?
220, lord.
Read 220.
The Brahma learned counsel for the applicant is present. There is a matter fixed for report of circle officer. However, it
Which order you are impugning?
This order is also this is the final order that has been passed in the land grabbing.
No,
case.
which order you are impugning?
This order, lord.
This order relates to.
This order.
Okay, read the order.
Learned counsel for the applicant is present. Today, the matter is fixed for report of circle officer. However, it appears that the applicants have not taken steps to call for said report. This is factually incorrect, lord. A petition bearing number so and so is filed on behalf of the applicant order 1/2 of the CPC seeking to strike out the name of the applicant number 3 from the array of parties on the ground that the applicant has come to know from reliable source. The respondent number 3, Piyush Pariwal, has expired. That today under section 94, read with section so and so CPC and so and so one district case number so and so, which was filed by the petitioner, have been dismissed with cost of 5,000. While hearing the argument in the said mystery case, it transpired that the applicant have filed the instant land grabbing case with false statement. In the instant application, it is alleged by the applicant that the land of the respondent number one adjacent to the land of the applicant and taking advantage of being the owner of the adjacent plot of land. The respondent number one, in collusion with other respondent, is trying to encroach upon the land of the applicant. whereas a bare perusal of the boundaries of land in question, schedule A, B, C, D land revealed, respondent number 1 is nowhere seen in any of the boundaries of the said plot of land allegedly purchased by the applicant. The allegation of the applicant that being adjacent of the to the land of the applicant, respondent number 1, is trying to encroach upon the land of the applicant completely false and baseless. Moreover, the instant application was filed by the applicant on 7/1/2025, alleging encroachment of their land by respondent, including respondent number 3, by criminal force. Today, the applicant have themselves filed petition bearing number so and so to strike out the name of Pius Peribal from the array of the parties on the ground that from reliable source applicant came to know that the respondent number 3 Pius Peribal expired. It is relevant to mention here that the respondent number 1 during the proceeding of Mijri case number 7 categorically pointed out that Pius Peribal died on 15/7/2022, meaning thereby a false case has been presented by the applicant before this court to obtain favorable order by making a false and incorrect statement. It appears that the main purpose of the applicant in filing the instant case and the provision of the so and so is somehow to obtain ad interim injunction against the respondent, and they can make out a civil case to get land mentioned in the schedule of the alleged sale deed. It appears that the applicant are not interested in pursuing the application, the instant land grabbing case. That is why the applicant are filing application one after another seeking ad interim injunction with false statement. In this view, dismissed with 10,000 possible. Now, first statement, Lordship, that a report was not called for from the circle office, Milord, is incorrect, Lordship. That Lordship can kindly see page 29.
No, we will examine.
Lord, may, Milord?
We are issuing notice.
Lordship may state the order, Milord.
What order can be?
This order has to be stated because we
It
have.
has been, it has dismissed your case.
Yes, Milord, but we have been.
Stay would revive your case.
No, Milord. We are directed to pay a cost of 10,000. So that order needs to be stated, Milord.
No, that has to be examined.
Lordship can hear me, Milord. If Lordship is not satisfied, we will not press for it. I will hardly take 10 minutes, Milord.
No, not at this stage.
Milord, but if the order is not stated, we will be violating the order, Lordship. So Lordship will grant it stay till the next date, Milord. I am not praying for any, we have filed an injunction petition. I am not praying for an injunction because they have already taken possession of the land, most of the land. But till that Lordship may stay, this order has to be stayed, Lordship. Or Lordship, here we Lordship not
Heard
satisfied.
Mr. A. Lal, learned counsel for the petitioner. This application under section 115 of the Code of Civil Procedure 1908 has been filed by the petitioners impugning the order dated 8/4 2025 passed by the Court of London, Additional District Judge number 1, Kamrup Metro, Guwahati, in special land grabbing case number 1/2025. Issue notice to the respondents and call for the records of special land grabbing case number 1/2025 from the concerned court. The petitioner shall take steps for issuance of notice upon the respondents within 7 days from the date of this order, returnable on 8th of January 2025. To whom this is to be done? To DLSA.
Lordship.
Considering the contentions raised by the petitioners in his application, the operation of the impugned order to the extent it has directed, by which, to the extent by which it has directed the petitioner to pay cost of rupees 10,000 shall remain stayed till next returnable date, list accordingly.
There is I belong in the I also was dismissed with cost of same order loss. It should be also stayed with
I for what?
I for injunction loss.
What injunction?
That's it. We are still in possession of some portion of the land and we are apprehensive that they will take over the position. So we are not pressing for that, not to that extent losses. We have not seen the complete.
You are withdrawing the IA.
No, not within the losses. Same order, let it be stayed. I also be directed to pay cost loss. So that we stayed, so that part we stayed and let it come
No,
on.
I
You will have to take the impugn order, my lord.
there is the impugn order is.
There are three
Okay.
cases that were filed, my lord. One Mizje case 7, one Mizje case 25, and one the land grabbing case. Mizje case 7 and Mizje case 25 were dismissed with the cost of 5,000 each, my lord. Whereas the main case was dismissed. with
But
the
you
cost-
have to file a main case impugning the.
We have
in
filed
the
the
ma-
the
ma-
main petition, we have filed.
Main
the-
petition, you have challenged only one order.
Thus you can see the clause in the petition. Call for a record of the special case number 1 along with Mizje case number 7 and Mizje case number 25, which has been disposed of by the learned judge number 1 so and so, issue notice and stay below pending disposal. We have read all the 3 orders to be taken. Lordship can add these 2 orders in the main case also, my lord. So
No, I cannot add.
that is lordship.
In the CRP, you have impugned only.
No, the CRP page 36 lordship may kindly.
What is your pair in IA?
I is for injunction law.
We are not dismissing it today. You think it over on the next date.
The I, my lord.
Yes,
Lord, I have a case for injunction law. We will satisfy lordship on the next date.
we are passing no orders today.
Item 9. Obliged, lord.
May it please, madam. By way of this CRP, my lord, we have assumed the order dated 16/9/2025 against the dismissal of our appeal under section 9 of the public premises eviction of unauthorized occupants act 1971. But here I submitted, my lord, already 3 matters of similar nature, my lord, are pending. And in those matters, my lord, already notices have been issued. So may I pray that this matter may also be tagged with those matters, my lord. I have the orders, my lord.
Yes.
In fact,
Issuance of notice.
some of these matters, if your worship considers it fit.
But other
Other
three,
cases-
other three are heard Mr. A. Iqbal, learned counsel. A. Iqbal, learned counsel for the petitioner. Also heard Mr. R.K. Dev Chaudhary, learned Deputy Solicitor General of India, representing the respondents. This application under Article 227 of the Constitution of India has been filed by the petitioners, praying for now impugning the order dated 16/9/2025 passed by learned Court of Learned Additional District Judge number 1, Kamrup Metro in Miss Appeal number 82/2021, whereby the said appeal referred by the present petitioner was dismissed and the order of the estate officer NF Railway passed on 25/8/2021 in eviction case number
Lordship will find it page 86.
EO/MLG/05/2021 was upheld. Since Mr. Dev Chaudhary has appeared for all the respondents, no formal notice need to be issued to the respondents. Records should be necessary. Learned counsel for the petitioner has submitted that in three other similar how these three cases are connected with this case?
All these cases were filed together. They were doing business on railway line and it was.
But they are separate cases, separate land.
Separate lane, my lord.
So why to tag? We,
Similar nature, my lord. We are saying,
but all similar nature cases,
we are saying that it's a government land. They are saying that it's a railway land, my lord. And the notices are also of the same year, same date, my lord. And these appeals were also taken up together, my lord. So it will save the time of the court, my lord. That's why I have suggested. I'll leave it to you, lordship. Otherwise.
okay. Learned counsel for the petitioner submits that three cases between same parties which are of similar nature,
But similar nature. Same subject.
which are of the similar nature. Notices were issued and praise for listing this matter along with the same said cases, namely CRP number 158/2025, CRP number 159/2025, and CRP number 160/2025. Stop. Let the records of the appellate court as well as the concerned record of eviction case from the estate office, NF Railway be called for. Let this matter be, any date has been fixed?
No, my lord.
Let this matter be listed after 4 weeks, along with the aforesaid CC civil division petitions. List accordingly.
Deeply obliged.
Your Lordship. Your Lordship, on behalf of engaged counsel D. Mandal, the matter may be adjourned for today, Your Lordship, as due to some personal difficulties. And considering the urgency of this matter, Your Lordship, the matter may be fixed on Wednesday.
Heard Mr.
A.N. Iqbal.
A.N. Iqbal, learned counsel submitting on behalf of Mr. D. Mandal, learned counsel for the applicant, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed on Wednesday, 26/11.
Item 11.
This matter may be taken up after some time.
Okay, after something.
Right, please, your lordship. My lord, impugn order, my lord, at page 136, my lord, the last but one page, my lord. Here, my lord, the petitioner before your lordship is the defendant number 2. And he has purchased a plot of land from defendant number 1, my lord, by registered sale deed. And thereafter mutation was granted, land revenue, my lord, has been paid. and boundary wall, Akka boundary wall was constructed, and thereafter, my lord, one godown, several shops and residential houses have been constructed. And in the meantime, my lord, what happened, my lord? The plaintiff, who is the son of the defendant number one, filed a suit, my lord, for right title interest and for recovery of first possession as against his father. That is defendant number one, my lord. And suit was subsequently proceeded ex parte as against us, as because we did not receive any notice, no summon, nothing of the sort. So ultimately, we did not know about the finalization of the suit. And the moment we have got a summon from the executing court, and immediately thereafter, my lord, we have come to the court, consulted with the advocate, consulted with the record, and then we have found that suit was proceeded as against us, my lord. And then filed, my lord, we have filed a petition, my lord, under order 21, rule 26, my lord, for staying the execution. But in the meantime, my lord, the revenue staff and the my lord Nazir and all, my lord, they visited my houses in order to demolish the houses and all. And immediately thereafter, my lord, we have filed this petition, and that petition has been rejected only on the ground that no irreparable loss was shown to be in the petition, my lord. And my lord will find in my petition I have annexed that I have stated all
Ex parte decree was passed against you,
against, yes, against both, my lord.
against you.
Yes, my lord, in the suit.
Then you have not challenged that ex parte decree, neither restore setting aside of ex parte decree.
We have challenged it. We
Then-
have challenged it by filing a petition, my lord, that is now pending.
That is pending.
That is pending, my lord.
Okay,
In the meantime, my lord, execution case has been
Okay,
filed.
Okay.
And in that execution case, my lord, they wanted to demolish the houses. And thereafter, this petition has been filed before the executing court.
Mm.
And my lord, at this stage,
So
my lord,
during the pendency of your Order 9 Rule 13 application,
my lord,
you filed this Order 21 Rule 26
my lord, my
application.
lord. One before the title suit, my lord, that was for setting aside the ex parte judgment and decree, my lord, that is pending, my lord. And the next date is on 26, my lord, of this month, my lord. And the executing court has fixed the matter, my lord, on 1st of August. Sorry, my lord, 1st of December, my lord, for report. And in the meantime, my lord, they have visited our house. They say they remove everything, all structures are going to.
Heard Mr. M.H. Chaudhary, Learned Senior Counsel, assisted by Mr. R. Barwa, Learned Counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner Jumar Ali, impugning the order dated 4/8/2025 passed by the Court of Learned Civil Judge Junior Division Number 2, Darong, Mongolda, in whereby the prayer for stay of execution in title execution case number 3/2023 made by the present petitioner was rejected. Learned counsel for the petitioner has Learned senior counsel for the petitioner has submitted that the petitioner was the defendant in the title suit number 22/2017, in which he did not receive any summons. You did not receive any summons. And the suit proceeded ex parte. Ultimately, the suit was decreed ex parte. However, after suit was decreed ex parte, and a title execution case number 3 of 2023 was filed. The Learned Senior Counsel for the petitioner submits that the petitioner came to know about the ex parte decree only on when you came to know?
After receiving summon, my lord, from the executing court.
After receiving notice from the executing court in title execution case number 3/2023. He submit that immediately the petitioner approached the trial court by filing an application under Order 9, Rule 13 for setting aside the ex parte decree passed in title suit number 22/2017, on the basis of which Miss case was registered.
Yes, Miss case 100/2024. my lord.
Miss case number 100 of 2024 was registered, and which is still pending for disposal. In the meanwhile, as the execution, as the decree holder proceeded with the execution case, the petitioner approached the executing court by filing an application under Order 21, Rule 26 for stay of the execution on the ground that an application for setting aside ex parte decree filed by the present petitioner is pending. However, Learned Senior Counsel submits that the executing court, without considering the relevant facts, dismiss the application for stay of execution, holding that no irreparable loss would be caused to the present petitioner. It is a homestead land.
Homestead lane, my lord. My lord, in my petition, I have stated, my lord, the residential houses is there, one godown is there, 4 shops are there, boundary walls are also there.
Learned Counsel for the petitioner submits that in the decretal land, residential houses, 1 godown and shops are there, and if same are demolished in execution of the ex parte decree during the pendency of the application, during the pendency of Miss case number 100/2024, he would suffer irreparable loss and injury. Hence, he submits that the executing court had erred in rejecting the application filed by the present petitioner under Order 21, Rule 26 of the Code of Civil Procedure. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with by speed post within 3 days from the date of this order, returnable on 18th of December 2024. Stop. In the meanwhile, considering the submissions made by Learned Senior Counsel for the petitioner, as discussed in the foregoing paragraphs, further proceeding of title execution case number 3/2023 shall remain stayed. List accordingly.
I do, please.
This is a civil contempt case. The allegation against the contemptors are that they violated the orders of the trial court as well as the revisional court.
So there was a case registered in STOPS case number 79 of 24 for a case of theft. Pursuing that case, the IO has seized some on 17/8/24. The IO led by SI Dipankar Dole seized some items which are scrap used batteries from the location of the petitioner. His godown is situated at Amingaon. So on suspicion of theft items, those items were seized by the IO and taken to the TO police station. The petitioner then filed a GMAP application before the learned CJM Jorhat.
Total contempt of courts act.
Before the
Yeah.
learned, and the
Contempt of courts act. Yes.
and 2 days later, the complainant also filed a GMAP petition for the same items. Then the learned additional CJM on 6/11/2024, after hearing both the sides, gave the interim GMA to the complainant of the case. But imposed some conditions. May I read the conditions, page 32.
Yes.
That the scrap batteries to the petitioner, Mr. Hasinur Rahman, proprietor Hasinur Enterprise, TOP on execution of a GMA bond of 12 lakh rupees only, subject to
Contempt
production
of
of payment
courts
of IGST certificate of rupees 1,90,228.
কি বললেন? Lawyer. Yes.
Rupees 1,90,220. Let a copy of
What
this,
condition has been violated?
that he has to give a GMA bond of 12 lakh rupees and he has to furnish a certificate as regards to the payment of IGST amounting to rupees 1,90,228. That means the items were valued of 10 lakhs. In that 10 lakhs, 1,90,000 was shown as IGST. We have challenged that he has not paid the IGST, so his bill was fake. So the court has imposed a condition that he has to deposit the IGST.
You
This
have,
order was passed on 6th.
you have reported the matter to
Yes, what's it? That this order was passed on 6/11/2024, a Saturday. On 8/11/2024, the Honorable Sessions Court of Jorhat stayed the interim GMA order. It is in page 34 and 35. The order was passed, GMA order was passed on 6th Saturday. On 8th Monday, it was stayed by the Sessions Court. Later, it was discovered that the items were delivered to the complainant on 9th. That means the IO did not follow the direction of the trial court as well as of the revisional. In this regard, the IO was given a so cause notice by the learned trial court, additional CJM Jorhat. May I come to page 40?
yes.
Page 40.
IPC
Investigation
did-
officer gave GMA of the scrap batteries to the petitioner Hasinur Rahman on 9/11/2024, whereas it was stayed on 8/11. It is further to be mentioned that in compliance report submitted by the IO, SI Dipankar Dole, he has not mentioned whether he has granted the GMA by obtaining IGST certificate of rupees 1,90,000 or not, which was a precondition for granting GMA. Hence, I direct the IO to submit another report along with the certificate of the IGST issued by the proper authority, fix 2911. So what he has replied is on page 41.
What is the reply?
Reply, it is on page 41. Sir, with reference to the subject cited above, I have the honor to report that I have submitted a compliance report before your honor on 19/11/2024 as per your kind order. Further, I have the honor to report that I have consulted with the Office of the Deputy Commissioner of State Tax, Jorhat, and it came to learn that there is no separate IGST certificate of 1,90,000 amount, and is included on the same along with e-way bill so and so generated on so and so, which is 6. That means he has sought an opinion of the Office of Deputy Commissioner of State Tax that no IGST certificate is separately given. But in the JIMA order, he was asked to obtain the payment of GST certificate. That means he has to pay and obtain a certificate that the amount has been paid. And he is reporting that there is no IGST support certificate. If there were any confusion as regards to the payment or non-payment, he should have get it clarified from the competent court. Instead of getting it clarified, the order was passed on 6th. It was stayed on 8th by the revisional court, and on 9th he has released the item on his own without complying with the condition of the JIMA order and
Then
bypassing the sessions
have
court.
you reported the matter?
Yes, I have reported the matter, and it is on page 42. Compliance report is received as called for. Dipankar Dole. Keep the report tagged with the record of the future reference. Seen an application filed, application bearing number so and so filed by learned advocate so and so, whereby CS prayed for taking appropriate legal action against SI Dipankar Dole and Hasirur Rahman, proprietor of Hasirur Enterprise, for violation of JIMA order dated so and so passed by this court. I do not deem it fit to pass an effective order on the petition so filed by the learned counsel until the Honorable Revisional Court passes final order on revision petition filed referred by the Nirman Industry. So revision petition was not against that violation of the JIMA order. It was on merits of the JIMA order. So the trial court did not pass any effective order on our appeals. We have informed. So it is a clear cut.
What was your prayer?
You want the
Prayer before the trial court?
before the trial court to take action against the IO because he was there.
Read the prayer portion.
Seen an application filed bearing so and so preferred by the learned advocate Kyle Ghosh, whereby CS prayed for taking appropriate legal action against SI Dipankar Dole and Hasirur Rahman, proprietor Hasirur Rahman, for violation of JIMA order dated so and so passed by. So this is a clear case of contempt. He has bypassed the JIMA.
But that contempt is punishable under law, under IPC.
So we have filed it under the contempt of court.
No, whether it is punishable under IPC or not.
No, at least he can rectify by. proceeding
Suppose he has disobeyed the court's order. Is it a punishable offense?
Not under IPC.
You have checked it.
I'm not.
Otherwise it will, this court will not have jurisdiction. If it is punishable under IPC, then read section 10 of the Contempt of Courts Act.
Or section 10.
Proviso.
Power of High Court to punish contempt of subordinate courts. Every High Court shall have the exercise and same jurisdiction, power and authority in accordance with the same procedure and practice in respect of contempts of court subordinate to it, and has exercises in respect of contempt to itself, provided that no High Court shall take cognizance of contempt alleged to have been committed in respect of subordinate court as to where the contempt is an offense punishment, as to it where such contempt is an offense punishable under Indian Penal Code.
Yes, you answered this query. If it is a punishable offense under IPC,
Then
then
this won't attract contempt.
then course is different, then
Yeah.
you have to approach the trial court.
May I read the definition of the civil contempt?
No, you answer my query.
If there is an existing provision of punishment of such an offense,
Yes,
then contempt of court won't affect.
you will. We'll take it, this matter tomorrow or day after tomorrow. You answer my query, whether your case overcomes the proviso to section 10 of the Contempt Act. Only in that case we will have jurisdiction. Otherwise,
Yeah.
you have to approach the trial court.
Violence.
Heard, Mr. What is your name?
MD Khan,
MD Khan. MD means Muhammad.
Muhammad.
Heard means heard Mr. Muhammad Khan, learned counsel for the petitioner. This application under section 10 of the Contempt of Courts Act 1971 has been filed by the petitioner alleging violation by the respondents of the order dated 6/11/2024 passed by the Court of Learned Additional Chief Judicial Magistrate Jorhat in Jorhat PS case number 79/2024, as well as violation of the stay order dated 8/11/2024 passed by Learned Sessions Judge Jorhat in Criminal Revision number 35/2024. A query was posed by this court to the learned counsel for the petitioner as to whether the violation alleged by the petitioner in this case amounts to an offense under the provisions of Indian Penal Code.
Yeah.
Indian Penal Code. So as to overcome the Indian Penal Code, and whether the embargo of proviso to section 10 of the Contempt Act is applicable in this case. Learned counsel for the petitioner seeks some time to answer to the query posed by this court. The time is granted when? 26th. Let this matter be listed on 26th of November.
Lordship. Lordship, this matter earlier was rejected.
You
by
have
your
not taken
lordship.
steps.
It's through PP office, but I have seen the registry note which says that section it is not received. So may I pray lordship that this matter is earlier rejected by your lordship. So records already called in that bail application. So if
No, taken steps for issuance of notice upon respondent.
that you have taken.
But my lord, in the office note, that is not reflected, my lord.
Office note says that not received from section. Because so from instruction.
Not received from section, not received by the section. That means you have not taken steps. What is there to show? If you have not taken step, then we will dismiss this bail application. You show something.
Now, lordship, I don't have anything because as per my clerk instruction, I was told that steps have been taken through PP office.
When you take steps, you are given some acknowledgement.
Through PP office, so they don't give any acknowledgement.
No, madam, it is always routed through the registry, madam.
But through registry, it is not taken. That is I'm sure.
Then, madam,
You take steps.
And regarding this record lordship,
Heard Ms. T. Som, learned counsel for the petitioner, also heard Mr. K. Basho, learned additional public prosecutor. On perusal of the office note dated 17/7/11/2025, it appears that the scan, it is a POXO case.
Yes,
My lord,
lordship.
POXO matter, my lord.
Lordship.
What is the stage?
Stage lordship, after lordship's refusal, no witness has turned up and he is still behind the bar.
It appears that from the office note dated 7/11/2025 that scanned copy of the trial court records have not been received. It also appears that the petitioner has also not taken steps for issuance of notice upon the respondent as number 2 as was directed by this court. Learned counsel for the petitioner has submitted that though as per her instructions, the petitioner has already taken steps as was directed by this court. However, she is ready to take fresh steps. She further submits that the trial court records were earlier called for in connection with bail application number
2693/25.
2693/2025 and therefore pays for calling of the records of the said bail application. The prayer is allowed. However, let a status report of the trial of the POXO case number
My lord, special POXO case number 94/2024, my lord,
special POXO case number 94/2024
pending before the court of the learned.
pending
Special Judge
before the
Vishwanath.
court of learned special judge Vishwanath be called for from the concerned trial court. The petitioner shall take steps for issuance of notice upon the respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 17 December. Agotala, 12 December. List accordingly.
And if the
For admission, item 16.
Made to the lodge. So this is a statutory appeal, my lord, against the order dated 4/1/2025 passed by the learned district judge in probate case number 1 of the 2018.
Granting probate or refusing it?
Refusing, my lord. Basically on 2 grounds. Case of dismissal.
Heard Mr. N.J. Khatuniar, learned counsel for the appellant. This appeal under section 299 of the Indian Succession Act 1925 has been preferred by the appellant, impugning the judgment and decree dated A4/1/2025 passed by the Court of Learned District Judge Jorhat in probate title suit number 1/2018, whereby the prayer for grant of probate by the present petitioner, present appellant was rejected by the trial court. Issue notice to the respondents and call for the records of the trial court. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days, within a week from the date of this order, returnable after 4 weeks. List accordingly.
Obliged, lord.
Item 17.
But if the prior of probate is rejected, they can note that the mandate mandate of the section 63 is not fulfilled.
Heard Mr. F.Z. Mazumdar, learned counsel for the appellant. This appeal under section 299 of the Indian Succession Act 1925 has been preferred by the appellant.
Page 19 is the order. An order
Appellant
dated 9/10/2025.
impugning the judgment and order dated 19/8. Order dated
An order dated
19/8. 19/8/2025, passed by the Court of Learned District Judge Kachar in Miss Probate case number 16/2023, whereby the prayer for grant of probate to the present petitioner was rejected. Issue notice to the respondent. Who is the opposite party?
Lordship, only the district commissioner because the districts does not have any legal head and she was alone. And in the trial court, no was implicated as a party other than
On what ground your prayer was rejected?
that section 63 says that the witnesses must seen the testatrix at the time of signing the will. And my petition as well as the examination in chief states that they have seen, but somehow the learned court below overlooked it.
Okay. Okay, Mr. T.R. Gogoi,
Lords.
Learned Government Counsel, appears for the sole respondent. Hence, no formal notice need to be issued to the respondent. However, let the records of the misprobate case number 16/2023 be called for from the trial court. Registry to issue registry to take steps for requisitioning the aforesaid records. Let this matter be listed after 4 weeks on receipt of the trial court records.
One thing, Lordship, very surprisingly, the witnesses, the attesting witnesses were also not examined by the learned
Let the records come. We'll examine it.
Lords. Alright.
May it be pleased, your lordship. Lordship, it is a statutory appeal under section 23 of the Railway Claims Tribunal Act 1987 against the judgment and order dated 21/7/2025 passed by the Railway Claims Tribunal, Guwahati Bench in original application number where
Heard Miss, what is your name? Heard Miss M. Kolita, learned counsel for the appellant. Also heard Mr.
A.K. Medhi on behalf of Mr. S.K. Medhi, CGC.
A.K. Medhi appearing on behalf of Mr. S.K. Medhi, learned Central Government Council. This appeal is preferred under section 23 of the Railway Claims Tribunal Act 1987 by the appellant, Messrs. Padmavati Trading Company, impugning the order dated 21/7/2025 passed by the Railway Claims Tribunal, Guwahati Bench in original application number OA Roman 3-105/2015, whereby the claim of the present appellant was rejected. Since Mr. Medhi has appeared for the sole respondent, no formal notice need to be issued to the respondent. Stop. Call for the records from the call for the concerned record of original application from the Railway Claims Tribunal, Guwahati Bench. Registry to take steps for requisitioning the records. Release this matter after 4 weeks after receipt of the trial court records.
Extra copy maybe, sir.
The petitioner is directed to furnish extra copies of memo of appeal along with the annexures to the Learned Council, Learned Central Government Council within a period of 2 days from the date of this order. Date of this order.
Item 19.
This is an injunction appeal. At this stage, only notice will go, man.
Heard Mr. D. Majumdar, Learned Senior Counsel assisted by Mr. G. R. Datta, Learned Counsel for the appellant. This appeal under Order 43, Rule 1 within bracket R of the Code of Civil Procedure 1908 has been preferred by the appellant, impugning the order dated 9/7/2025 passed by the Court of Learned Civil Justice Senior Division number 1 Kachar in Ms. J case number 46/2023 in connection with title suit number 28 of 2023, whereby the prayer for grant of temporary injunction made by the present appellant was
Granted, man, in the form of status quo.
rejected. However, the parties were directed to maintain status quo in respect of the suit land. Stop. Records would be necessary. Scan cover, not necessary. Okay. Let the notice be issued. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Item 20.
May please, madam. While hearing this case, the plaintiff had instituted a suit for declaration of right title interest and recovery of possession. Against that, the defendant entered appearance and they filed a written statement come counterclaim. Now, during the pendency of the suit, my lord, the defendant they filed an application that my lord will find at page number 71. Annexure 6.
Yes, what application?
Application not to disburse the compensation amount in respect of a land measuring, my lord, covered by DAG number 293, patta number 288, which is not a part of the suit land, subject matter of the suit, my lord.
Suit is for?
Suit is for declaration of right title interest and recovery of possession in respect of another plot of land. If my lord sees the plaint, the scheduled portion, my lord will find.
No, which, where is the impugn order?
Impugn order was find, but I'll just place the facts. Hereafter, my lord, an order was passed that my lord will find at page number.
This was the compensation amount means that land has been acquired.
By the collector.
Okay.
For Bharat Mala project. So thereafter, the defendant filed an application not to disburse the compensation amount to the plaintiff or to any third party. So I am the third party, my lord. I am in possession of the land. Neither the plaintiff nor the defendant, they are in possession of the land.
In that suit, the petition was filed.
In that suit, I filed the petition. The defendant files file. Thereafter, this order was passed, my lord. 75 at page 75. Without giving an opportunity to the plaintiff or opportunity to us, my lord, this order was straight away passed on the very same day. Order dated 28/2/2025 at page 75. May I read, ma'am?
It is a long order.
I'll just, in view of the last paragraph, my lord, in view of the extreme urgency, this order is passed without hearing the plaintiff
as non-granting of immediate relief may render the suit
Mm.
infructuous and lead to injustice.
Compensation was directed to whom?
To the present petitioner, my lord.
Who is not a party to
Who is
this
not a
suit?
party to this. And there's a specific bar under section 63 of the right to acquisition, my lord. Bar
2013 Act.
section 63, which says that civil court jurisdiction is barred in respect of compensation, apportionment,
Right to fair
right to fair
compensation.
compensation and transfer.
No, what, let us read the order.
My lord. My lord will find at page, the impugn order that is there, my lord will find at page
77.
70. 77 is not the, that is the first order, my lord, that was passed. Hereafter, we filed a petition, my lord.
What petition?
That order, this order should be set aside because it was passed without hearing us and there is a bar, my lord. And
Okay.
moreover, my lord, we are in possession of the land and it is not the subject matter of the suit.
You are not impugning this order.
As well as the final order, my lord.
No, my petition is at page 75,
Or 75. Okay.
not 77, 75, man.
77, 75.
75, annexure 7.
Okay, first read 75.
CR is put up on strength of-
75 was passed on the orders of the defendant.
on the petition filed by the defendant. On the very
Yes,
same day.
Yes,
CR is put up on the strength of petition number 363 of 2027 filed by the defendant side, praying not to disburse any compensation amount to the plaintiff or any other person under Bharatmala project relating to the suit land. Upon considering the submissions made by the learned counsel for the defendant and perusing the materials available on record, it is evident that the land in question is the subject matter of the instant suit, which is pending adjudication before this court, and the suit land attracting DAG number 293, Patta number 288, Khatia number 135, Moza Lokar Khai, which allegedly falls under the Bharatmala project. Since the matter is extremely urgent and fact that the land in question is the subject matter of the instant suit pending before this court, it is necessary to issue immediate directions to prevent any irreparable loss or complications. It is further observed that directing the disbursement of the compensation amount at this stage may prejudice the rights of the defendant and affect the fair adjudication of the matter. Hence, to prevent any injustice, the court deems it necessary to restrain any disbursement of the compensation amount until further orders. In view of the extreme urgency, this order is passed without hearing the plaintiff, as non-granting of immediate relief may render the suit infructuous and lead to injustice. However, such an order does not cause prejudice to the plaintiff since the matter remains sub judice before this court. Accordingly, the District Commissioner Sri Bhumi is directed not to disburse the compensation amount to any person until further orders.
how much area this land contains? Dag number 293.
Look, I
Ah,
have annexed the general-
Whether plaintiff also had share in this land?
It was an ancestral property, my lord. So after an amicable
No,
settlement,
whether this 293, Pata number 288 is the subject matter of the suit.
no, it is not the subject matter. That is my first submission, my lord. It is measuring, my lord, 16 kotha, 15 chataks at page number 88. It, my lord, it's the schedules of the plaintiff, my lord, at page 32. Nowhere it is mentioned that, my lord, DAG number 288, 293 of KP Pata number 288 is there, my lord. Neither in the counter claim.
What is the description, Dag number, Pata number?
The acquired land is, my lord, DAG number 288, new DAG number 293 under Patta number 288 of Khatia number 135. Which we have mentioned at page number 77, annexure 8, man. Very first paragraph. DAG number 293, Patta number 288. There is neither in the schedule of the plain nor in the counterclaim it is given.
No, this order dated 8/2/2025, 28/2/2025 does not mention in respect of which land the compensation was to
My lord.
be.
But in the petition, they have stated, my lord, in the petition at page number 72, para 5. They have stated.
What they have stated.
They have said para 5 that considering the facts and circumstances, defendant finding no other alternative and submit this petition for passing necessary order, directing the district commissioner and his officials, LA branch Sribhumi not to disperse.
No, what was the case of the defendant when they filed the petition?
But defendant case was that they are in possession of the land, confirmation of possession, declaration of right title interest, and cancellation of a partition deed
In the suit,
in the suit.
in the suit, no, in the petition which was filed for staying the disbursement of compensation.
My lord,
In the petition which they filed on 28/2/2025,
my lord.
what was the contention for staying the
Here,
disbursement?
my lord, the dark number and the patta number for which the land was acquired, that is the subject matter of the suit. Because, my lord, it also comes, because they sought for cancellation of a partition deed. So that was the subject matter of the partition deed. But, my lord, I have gone through the partition deed. Even I have a copy, my lord may also go through. I have nowhere find, my lord, in the schedule that dark number 293 covered by KP patta number 288 is a part of the partition deed, my lord. The partition deed is there, my lord. I have marked the schedules also. The schedule of the land starts from fifth page, my lord. There are a number of schedules given, but not a single schedule speaks about dark number 293 covered by KP patta number 280.
Read para 4 at page 72.
The defendants, after getting the information for the illegal acts and deeds of the plaintiffs, the defendant forthwith submit complaint petition dated 19/2/24, 28/11.
No, before that para, from para 2.
Para 2. That the defendant numbers 1 to 5 after receiving the summons submitted joint written statement and counterclaim alleging inter alia for the cancellation of the partition deed number 2978 dated 19/5/2004, which is forged, void, illegal, fraudulent, collusive, created by the plaintiffs in collusion with his sharers by including the defendant's share for his illegal and wrongful gain, and the instant suit is pending for adjudication. That during the pendency of the instant suit, the plaintiff in collusion with others tried to withdraw the amount of compensation of land acquisition, which is acquired by the government of Assam for the purpose of Bharatmala project. That the defendants, after getting the information for the illegal acts and deeds of the plaintiffs, the defendants forthwith submit complaint petition dated 19/2/24, 28/11/24 before the DC Sribhumi, and also a copy submitted to the Circle Officer Sodor Circle, Sribhumi, Assam, not to disperse any compensation amount in favor of the plaintiffs and others attracting the land of the partition deed number 2978 dated 19/5/24. But the district commissioner or other officials did not pay any heed to the defendants, rather they tried to disperse the said compensation amount. That considering the facts and circumstances.
Okay. His submission is that the suit land is also subject matter of
But I've seen the partition deed, my lord. A number of times I have seen.
We'll issue notice.
Notice is already issued, my lord. It has come for admission. The other side has not appeared to them.
My lord, but they did appear before. They said that they will be filing objection.
Oh, they have filed objection also, man.
But that copy has not been served on us. state.
So my lord, there is another aspect.
But
to
my
this.
lord, the state, the deputy commissioner has not been made a party. The deputy commissioner himself, who is supposed to disburse the amount. And the 7 and 8, I am appearing on behalf of 7 and 8 respondents for the state. My lord, we have objection to paying the amount now because it will further create the problem, my lord. It will only increase the problem. As the court has rightly observed in page 93, the impugned order. My lord is yet to read the actual impugned order. Page 75 is not the impugned order.
Yes.
That is 93.
The petition passed on your order, your
My lord,
petition.
that is at page number 91, annexure 12.
Yes.
The relevant portion is at page 92, first paragraph. Upon consideration of the pleadings and materials placed on record.
Yes. No, reread the entire.
Entire 29 for 20. Parties are represented. Petition is filed by the plaintiff petitioner seeking to set aside the order dated 28/2/2025, by which this court had directed the District Commissioner Sri Bhumi not to disburse the compensation amount to any person in respect of the suit land until further orders. The ground urged by the plaintiff petitioner is that neither the schedule of the plaintiff nor did the counterclaim mention DAG number 293, and therefore the stoppage of compensation in respect of DAG number 293 is unjustified. The opposite party defendant filed objection and submitted that although DAG number 293 is not specifically mentioned in the schedule of the plaintiff or the counterclaim, he has in his counterclaim sought a declaration concerning deed number 2978 dated 19/5/2004. It is pointed out that the said deed pertains to land situated at Moza, Lakhorkhaya under Khotian number 135. The defendant has also submitted a photocopy of Jamabandi which shows that deed number 297 dated corresponds to DAG number 293. Heard both parties. Upon consideration of the pleadings and the materials placed on record, it is evident that the validity of deed number 297.
No, just a minute. We read third paragraph again. The opposite.
Party defendant filed objection.
What is their ground?
Their ground is that the DAG number and the Pata number is covered by the partition deed. That's why it should be stopped, because they have sought for cancellation of the partition deed.
DAG number 293 is not specifically mentioned. Khotian number is similar.
Khotian number is 135. 135 now Khotian number covers a lot of land, my lord. But covered by different DAG numbers, different Pata numbers. But 293 and Pata number 288 is not there in the partition.
In partition deed, a separate DAG number has been mentioned.
Well, I have given the copy, but 293 and DAG number 293 and Pata number 288 is not there in the partition.
Any specification of land by mentioning the DAG number has been there.
Not in the partition deed, my lord.
They have not mentioned any DAG number.
No.
Oh.
Other DAGs are there, but specifically DAG number 293 and Pata number 288 is not there.
Okay, then what court holds?
Court holds that, my lord, upon consideration of the pleadings and materials placed on record, it is evident that the validity of deed number 2978 dated 19/5/2004 has been challenged in the instant suit. The said deed includes land covered by DAG number 293. This is perverse, my lord. Although the DAG number is not explicitly mentioned in the schedule of the pleadings, the connection between the impugned deed and the DAG number in question is established through the Jamabandi record submitted by the defendant.
So there is a court has held that the land is subject matter
of the suit. That is held by the court, my lord. That is perverse, my lord, because it is not there in the partition deed.
Then that needs to be examined. Who is appearing for the respondent number 2?
Respondents, my lord, they had on the last few occasions.
Who is the counsel?
The name is shown, my lord. My lord, may I point out one thing, my lord? I think.
As Islam, I think.
There are
The
4
name is
councils,
showing
my lord.
as Islam.
Name of 3-4 councils are shown, my lord.
Yes, Islam.
My lord, it is true that compensation.
Then
amount-
what is to be done now? We'll give one, he needs to be heard.
Then let it come on the Wednesday, my lord, next Wednesday.
And a copy of the objection may be served on also.
I'll serve for him, my lord. I have received a copy filed by the respondents. I'll give it to him.
My lord, only thing, my lord, it is true that I know that the compensation amount will have to
Oh.
be given to the people who are in possession. But here the angle is there, the judge has already pointed out that whether they are in legal possession or not. Only if you are in legal possession, you are entitled to the compensation amount of the acquired land. That is true. But here, whether they are in legal, because the possession is also there, in the plain.
No, he has
Now-
raised the point of jurisdiction of this.
Jurisdiction of the civil court is barred, madam. Specifically, it is written, madam, section 63. There are a number of judgments also of the Honorable Apex Court. Jurisdiction of civil court is barred, section 63. Ma'am. May I just read out?
Yeah,
No
but then-
civil court other than High Court under Article 226 or Article 227 of the Constitution or the Supreme Court shall have jurisdiction to entertain any dispute relating to land acquisition matters in respect of which the collector or the authority is empowered by or under this act, and no injunction shall be granted by any court in respect of any such matter. So, madam, under Article 226 or Article 227, they can come, madam. But civil court has got no jurisdiction to deal with all such matters, madam. Then there is section 75 also of how apportionment has to be given to the parties, madam, with relating to title, with relating to disbursement of the compensation amount.
Okay, no, let Miss,
My lord.
the other side.
So, my lord, the district commissioner will have to be made a party because the situation has changed. What he has said is right in the originally. But after the case started in the lower court, our administration has here given in writing, my lord, the amount of compensation of the acquired and as per example, yet to be disbursed. So that
Yes,
position will be
Deputy
taken, my lord.
Deputy Commissioner,
But he is not a party in the suit, that's why.
No, that is another matter. But this is now legal requirement is there, my lord. If the DC is not made a party, it will not be fair.
you are also not party in this one.
He is a party in the suit.
You,
Party because, but I am an aggrieved person. ma'am.
so the payment will be made by the Deputy Commissioner. You have to. Heard,
And
Mr.
in that application, he can also clarify that he's in legal possession. That will help us.
That already I have stated in the petition filed before the trial court.
And if he can annex some papers also, my lord.
But notice was given to me, my lord. They have the records. my lord.
Heard Mr. G. Iqbal, learned counsel for the,
But
sorry. Heard Mr. A. Iqbal, learned counsel for the petitioner. Also heard Mr. K. Bhattacharya, learned government advocate, as well as Mr. A. Bhattacharya, learned standing counsel, Revenue Department. None has appeared for respondent number 5. Though name of Mr. S. Islam is reflected in the cause list. Stop. Learned government counsel, learned government advocate, Mr. Bhattacharya, has pointed out that since the Deputy Commissioner has been injuncted by the impugned order to disburse the compensation amount to the present applicant, the Deputy Commissioner Kachar would be necessary. Presence of Deputy Commissioner Kachar. Sri Bhumi
Change of name.
would be necessary for consideration of the instant revision petition. He further submits that though respondent number 5 has filed a written objection against the petition of the petition filed by the present petitioner, however, he has not received any copy of the same. On this, learned counsel for the petitioner submits that he is ready to furnish copy of the objection filed by respondent number 5 to the learned government council during the course of the day. He further submits that he may be granted some time to take necessary instructions and if required to file an application for impleadment of Deputy Commissioner Sri Bhumi as a party respondent in this case. The prayer is allowed. Let this when next week, No fixed date.
Next week and a date to be fixed.
Let this matter be listed on the next week on a date to be fixed by the district.
Take your place.
Item 45 from supplementary.
Caveat is there.
Yes,
Yes.
well, this is basically an injunction appeal. The plaintiff is the defendant here and we filed a caveat. The suit was filed alleging passing off by the defendant in the
Yes.
defendant in the suit. The facts are-
You are the defendant.
I am the defendant in the suit. The plaintiff deals with the business of the manufacturing and selling of
It is a commercial suit.
Doctor,
Yes.
a strong objection before going into the grounds as well of the merits, Your Lordship. I would like to raise the issue of maintainability of the appeals. Since appeal has been preferred against the order of the commercial court.
Yes.
May I? May I submit, Your Lordship?
Now, if he is on caveat, if he wants to address, your lordship may hear him first.
Only with regard to the issue of maintainability, Your Lordship. I would like to raise an issue.
Yes.
Lordship, this appeal is not maintainable, Your Lordship. The appeal has been preferred against an order passed by the Commercial Court of Jorhat, which is the court of the Civil Judge Senior Division. Any appeal against the Commercial Court would lie before the Commercial Appellate Court, Your Lordship, which is the court of the District Judge in Jorhat. Lordship, I would like to bring this court's attention to a notification of this, of the state government, Your Lordship. Now, Your Lordship, as per this notification, the state government has designated in each district the civil judge senior division as the commercial court and the district judge of each district as the commercial appellate court. Now, Your Lordship, under the Commercial Courts Act, for any commercial disputes,
Commercial Courts Act. Yes, any commercial dispute.
Lordship, any commercial dispute, any appeal. Your Lordship, section 13 of the act deals with appeals, Your Lordship, of the Commercial Courts Act. To be read
Yes.
with section 3A and section 21.
Yes.
Your Lordship may come to section 13. Amended for নতুন।
Yes.
May I read slowly, Your Lordship?
Yes.
Any person aggrieved by the judgment or order of a commercial court below the level of a district judge may appeal to the commercial appellate court within a period of 60 days from the date of judgment or order. Next, any person aggrieved by the judgment or order of a commercial court at the level of district judge exercising original civil jurisdiction, or as the case may be, commercial division of a high court, may appeal to the commercial appellate division of that high court within a period of 60 days from the date of judgment or order, provided that an appeal shall lie from such order passed by the commercial division or a commercial court that are specifically enumerated under order of civil procedure as amended by this act and section 37 of the arbitration Act. Lordship, the next point is very important. Subclause 2. This is a non-obstante clause, Your Lordship. Notwithstanding anything contained in any other law for time being in force or later patent of a high court, no appeal shall lie from any order or decree of a commercial division or a commercial court, otherwise than in accordance with the provisions of this act. appeal against the commercial court, your honor, appeal will lie in the commercial appellate court, which is the court of the district judge in Jorhat. This court does not have the jurisdiction to entertain this appeal. Same has been held by the Kerala High Court as well as the Delhi High Court.
Where is the impugned order?
There is a page. Page 130 of the appeal, your lordship. Your lordship, the intent of the legislature while enacting this Commercial Courts Act, which is a specific act, is very clear for speedy and effective disposal of commercial disputes. Now, the apex court in a number of cases, starting with Ambala Sarabhai, has held that the Commercial Courts Act has to be construed very strictly. No liberal interpretation can be given. Otherwise, the very purpose of enacting the act will be defeated. So your
Yes.
lordship, appeal against the order of the commercial court will lie before the commercial appellate court, your lordship, in Jorhat, that too. Not before this court, your lordship.
Yes, Mr.
I have strong
Datta.
objections against the.
Are you withdrawing or answering?
No, my lord, I'll try to answer it this way. My lord, the jurisdiction is also vested with regard to the pecuniary limit. The suit valuation
No,
has
no.
to, has also. to be
Because of the
fulfilled.
non-abstent clause in
No,
clause
that
article,
that
section
partic-
13.
Yes, that 13(2) does not deal with the aspect of pecuniary jurisdiction.
No,
In all,
no.
in all cases,
I'll come back
if
to
you
you.
complete- if
I'll
you are-
come back.
you complete
No, no, I
and their trial.
Yes.
Now, the 13(2), my lord, that does not deal with the aspect of.
But
pecuniary
this is a
jurisdiction.
commercial
Yes,
case
that is, this is-
that you are not disputing.
No, there is no dispute absolutely on this point. Question is whether this 13(2) will give unbridled power to the court of district judge or the district court, as the case may be, to deal with suit of any valuation as such. Because now the valuation stands that up to a limit of 20 lakhs, up to a limit of 20 lakhs, the district judge exercises the appellate power.
No, but with regard to commercial courts also,
No, in
pecuniary
regard to
jurisdiction is,
commercial courts also, my lord, the question of pecuniary jurisdiction will
is
come.
there.
Because
Yes.
otherwise, my lord, there would not have been any case for creating an appellate jurisdiction in the High Court.
No, what is your submission?
My submission is that, my lord, the objection that is taken, prima facie, my lord, the objection is with regard to the provision of 13(2).
Yes.
Now, if the suit valuation is looked into, then certainly, my lord, this will lie before this honorable court. Because the suit valuation was 50 lakhs, it has been valued as at 50 lakhs. Now, district judge's power to consider and hear appeals are up to a limit of 20 lakhs. It is the commercial court has merely recognized the appropriate court. It has not vested any new power to the courts. Because otherwise, all suits were to be instituted in the court of, all suits of certain value are to be instituted in the court of Assistant District Judge, which is now Civil Judge Senior Division. So from the suit, from the order of the Senior Judge Senior Division, my lord, it will have a bearing on the valuation of the suit itself. Otherwise, my lord, if your lordship will kindly see the 13(2) again.
Lordship, the pecuniary jurisdiction, High Court of Kerala has already dealt with that issue as well. With regard to pecuniary jurisdiction.
Any person, 13, any person aggrieved by the judgment or order of a commercial court below the level of district judge may appeal to the commercial court, appellate court within a period of 60 days from the date and judgment of order. Any person aggrieved by the judgment or order of a commercial court at the level of district judge, exercising original civil jurisdiction, or as the case may be, the commercial division of a high court may appeal to the commercial appellate division of that court within a period of 60 days from the date of the judgment and order. But it does not speak about the pecuniary jurisdiction.
Para 13(7.2) of that order, your lordship. Last page. In this case also pecuniary jurisdiction was not available, your lordship. However, with regard.
No, just a minute. I'll come back to you. Let him complete.
Therefore, my lord,
If the pecuniary jurisdiction, what is the suit value in this case?
50 lakhs.
If
Well,
the,
here also, my lord, as the things have unfolded, my lord, he had previously, the plaintiff had previously filed the suit in the Court of Civil Judge. Then the civil judge, looking into the aspect of trademarks, involvement of Trademarks Act, my lord, said that it will not be maintainable before the Court of Civil Judge. It ought to have been filed before the district judge. Then he filed the suit before the district judge. Now, thereafter, the district judge framed an opinion that it will not be maintainable at the court of the district judge because it's a commercial suit. So, then in that view, the suit was dismissed. Thereafter, he filed a review, and after filing of review, my lord, it was allowed to be withdrawn with liberty to approach appropriate court. That is how.
what is the pecuniary jurisdiction of the commercial court?
No, the original jurisdiction is with the civil judge. That he has, the district judge has rightly sent the matter to the court of the civil judge. But the valuation was done when the suit was filed initially before. I'm just giving the chronology, my lord. It was initially filed before the court of the civil judge.
No,
as-
let us go through the Commercial Court Act. What Commercial Court Act speaks about the aspect of pecuniary jurisdiction? Is it silent?
Well, I have not been able to put my hand on any angle on that.
Which
aspect.
para?
Para 37.2, your lordship. Last page. In this case also, your lordship, appeal was preferred before the High Court. The court held that this is not the correct forum. The question about the pecuniary issue was also raised, your lordship. It is dealt with at paragraph 37.2.
You have a copy of this judgment. Read para 30. Read para 37.2.
The Commercial Appellate Court at the district judge level designated under Section 3 of the Commercial Courts Act exercises jurisdiction in appeals filed under subsection 1 of Section 13 of the Act against the judgment or order of a commercial court below the level of the district judge. And the Commercial Appellate Division of a High Court constituted under subsection 1 of Section 5 of the Act exercises jurisdiction in the appeals filed under subsection 1A of Section 13 of the Act against the appeals from the judgment and order of a commercial court at the district level, exercising original civil jurisdiction, or as the case may be. Commercial Division of a High Court constituted under subsection 1 of Section 4 of the Act in the High Courts having ordinary original civil jurisdiction. The appellate jurisdiction of the appellate courts at a district judge level and that of the Commercial Appellate Division of a High Court is not limited by specifying any pecuniary limits. None of the provisions under the said Act empowers the state government to specify any pecuniary limit for exercise of the appellate jurisdiction, either by the Commercial Appellate Court at the district level or at the Commercial Appellate Division of a High Court. No pecuniary limit is there, your lordship.
Your lordship will kindly come to
No,
section
that
3.
is my question to you.
Yes, kindly come to section 3.
Section
3. Three, one, second proviso. Has your lordship got it?
3.1.
3.1, second proviso.
Yes.
Provided further that that is with regard to constitution of commercial courts. provided further that with respect to a territory over which the High Court have ordinary original civil jurisdiction, the state government may by notification specify such pecuniary value which shall not be less than 3 lakhs rupees and not more than pecuniary jurisdiction exercises by the district judge as the case, as it may consider necessary. So the question of pecuniary jurisdiction is very much involved. Otherwise there cannot be a suit in a commercial court, so to say, before the civil judge. Anyone can file a suit at any place, either before the district judge or the civil judge, as the case may be. So the pecuniary limit is otherwise prescribed. It should not be value of 3 lakhs and should not be more than the pecuniary jurisdiction governed under the relevant notification of the government. In our state, my lord, as I understand, my lord, the pecuniary jurisdiction of the district judge to hear appeals are up to a limit of 20 lakhs.
No, whether separate notification would be required in respect of commercial courts because it lays down a minimum.
Yes, minimum is 3 lakhs.
So maximum has to be laid down by the.
So that is so far as the original jurisdiction is concerned. If I understood
Yes.
the things correctly, my lord, with regard to the constitution of commercial court,
Your suit is valued at 50 lakhs.
50 lakhs.
So
naturally it is beyond 3 lakhs because to
no,
become a
no,
commercial
3
suit, my
lakh
lord,
is,
2 lakh,
therefore it is a commercial court.
yes,
So
since it is more than 3 lakhs, so
therefore
it's
it is
commercial
a
suit.
commercial suit.
Now after it becomes a commercial suit, it has to go to a court of particular jurisdiction.
Yes,
Now that jurisdiction is to be fixed by the state government by issuing a notification.
but you choose the jurisdiction you choose to file your suit before.
No, that was he. He filed the suit initially before the district judge, but later it was transferred, but he withdrew the suit and filed it before the court of civil judge senior division. So therefore, the question of pecuniary jurisdiction is intricately involved here. It cannot be said that merely because the district judge has been given the appellate power, he can exercise the appellate power irrespective of the pecuniary jurisdiction involved.
No, my understanding, you make me understand if I am wrong. Section 3, proviso 2 cast a duty upon the state government
Yes.
to fix the upper limit of the.
Now to demonstrate that before your lordship, my lord, as to whether there is a separate notification other than the ordinary notification issued by the government
But
regarding
ordinary notification is not in respect of commercial court.
No, that's what I am saying. So other than the ordinary notification, if there is a special notification issued by the state government defining the pecuniary limit, my lord, that aspect I'll have to check. That aspect I'll have to check because without checking, I should not say. But the general understanding is this, my lord, since the district judge's pecuniary limit is fixed otherwise, so far as the appeals are concerned, therefore this appeal has to come before this honorable court. But if your lordship wants me to answer this very specifically, my lord, then in that case, I'll have to check the notification.
Yes, please. You also find out how a litigant will decide whether to file a commercial suit before the civil judge or before the district judge.
Yes, because he
It
also
has-
filed the suit initially before the district judge.
It has to be on the basis of some pecuniary limit.
Your lordship, the pecuniary limit, this section 3, this is in respect of commercial court. We are dealing out here in an appeal. This is for the commercial appellate court. Pecuniary jurisdiction of 3 lakhs is for the commercial court. Any dispute whose suit value is more than 3 lakhs will go to the commercial court, your lordship. That is the pecuniary limit set for the commercial court. For the appellate court, no limit has been set. Moreover, your lordship, section 21 of the commercial courts act, your lordship, it has an overriding effect. May I read section 21, your lordship?
No, read the proviso to section 3 again.
Provided that with respect, provided further that with respect to a territory over which the high courts have ordinary original civil jurisdiction, the state government may by notification specify such pecuniary value which shall not be less than 3 lakh rupees and not more than the pecuniary jurisdiction exercisable by the district courts as may be considered necessary. So this pecuniary limit has been set for the commercial court, your lordship, in Assam. 3 lakhs has been set as per the notification. This is an appeal, your lordship, in pecuniary jurisdiction. The High Court of
To
Kerala.
decide whether a suit would be regarded as a commercial suit or not.
That is 3 lakhs is the threshold.
Yes, your lordship. 3 lakhs
Now,
is the
beyond,
threshold.
beyond 3 lakhs, my lord, because here your lordship will see not only the.
No,
civil
no,
judge-
this proviso only says that what would be the limit
Yes.
Yes, that has to be fixed by the,
state government to
government.
consider a suit to be a commercial suit,
that is minimum,
not to,
minimum is
Yes, sir.
prescribed, minimum is 3 lakhs.
yes.
Now, after having prescribed minimum, to which court it should go, it must have a connection with the pecuniary limit. Because all suits, because if the intention is to institute all suits regardless of the valuation before the civil judge senior division, then there would not have been any case of creating original jurisdiction in the district judge. Because if your lordship will kindly see, the appellate provision in the appellate provision.
Then you have to first raise the objection as to jurisdiction, pecuniary jurisdiction before the court where
No,
it.
we did not raise the objection regarding pecuniary jurisdiction. We are defendant in the suit.
Yes,
He filed the suit before, filed the suit initially before
but
the.
you have not raised that issue
No.
of pecuniary jurisdiction, lack
No.
of pecuniary
No,
jurisdiction.
that we did not take because the limit of the threshold limit of the constitution of criminal.
No, no,
sorry,
no,
commercial code,
no,
that was taken note of.
no, not on that. Yeah, try to understand my query.
Yes.
Your plea is that the suit is valued at 50 lakhs.
Yes.
So the Court of Civil Justice Senior Division does not have jurisdiction to entertain.
No, that is not my point. My
Yes.
point is that since the suit is valued at 50 lakhs, district judge will not be the appellate court. Because the ordinary pecuniary limit of the district judge to hear appeals are limited to a limit of 20 lakhs. Any suit valuation beyond 20 lakhs is usually heard by the High Court. So the justification for filing the appeal before this court is this, that since the pecuniary limit of the district judge to hear appeals are limited to the question of to the valuation of 20 lakhs, so beyond 20 lakhs it has to come before the High Court. But since your lordship is raising a query, my lord, I would like to answer it by checking the notification if there are any. So your lordship can take it up on Monday. I'll come back with the reply.
Okay, you also go through this ruling of Kerala High Court.
Yes, sir.
Well, that is, in my understanding, my lord, that is with regard, because every state is having their own notifications. Maybe, my lord, in Kerala, the notification is otherwise. And in some high courts, just like the Chennai High Court and Delhi High Court, they also have original jurisdiction, which usually we don't have. So that will also be another distinguishing factor. In any case, lordship may post it on 24th, my lord, I'll find it out.
Okay. Heard Mr. S. Datta, learned counsel for the appellant. Also heard Mr.
NN Datta.
N.
Datta.
Datta, learned counsel for the caveator. This appeal under this appeal you have filed under
43 Rule 1R.
this, that is again a question. Whether an appeal under order 43 rule 1,
Injunction.
oh yes.
Ultimately, injunction has been granted.
This appeal under order 43 rule 1R of CPC has been referred by the appellants impugning the order dated 12/11/2025 passed by the Commercial Court of London, Civil Judge Senior Division, Jorhat in Ms. J case number 146/2025, arising out of commercial suit number 11/2025, whereby the application for grant of temporary injunction filed by the present respondent under Order 39 Rule 1 and 2 was allowed. At the outset, the learned counsel for the cavator raised a plea of maintainability on the ground that the present appeal is barred under Section 13, under proviso to Section 13 Clause 2, Section 13(2),
Section 13 as a whole, your lordship.
under Section 13 of the Commercial Courts Act 2015. Whereas learned senior counsel for the this Bharat Likhibo, learned senior counsel Mr. S. Datta, assisted by Mr. A. Sahibal. Learned senior counsel for the respondent submits that learned senior counsel for the appellant submits that since the pecuniary jurisdiction of the district judge to hear an appeal is limited to the extent of suits valued up to rupees 20 lakhs only, and as the instant commercial suit is valued at rupees 50 lakhs, this appeal would lie before the commercial division of the High Court, before the High Court. This appeal would lie before the commercial division of the High Court or High Court. That is also a
There is
question.
commercial division, your lordship.
No,
notification has
there
been-
is one.
There is one.
There
That
is
is
one.
also a question.
Well,
Because-
the registry has listed it, my lord, that's why we are for your
Because
lordship.
if otherwise, if if it is found that this appeal lies, it will go to the designated bench.
Yes,
A designated bench is there.
yes, there, it is there.
So it will not come to this. But before that, we have to decide.
Your lordship may, for the present, my lord, your lordship may fix the matter on 24th. If your
Okay.
lordship gets satisfied that the appeal will lie, in that case, my lord, your lordship will consider placing it before the designated bench.
A question was raised by the court regarding the fact of regarding question was raised by this court as to whether there is a upper pecuniary limit of commercial court, upper pecuniary limit of Court of Civil Judge, Senior Division, while acting as commercial court, or as to whether the ordinary pecuniary jurisdiction will be operative in such cases also. To this, learned senior counsel for the appellant seeks some time to answer to the query. The prayer is allowed. Let this matter be listed on
24th.
24th of November, list accordingly.
Like,
Hearing under order 41(2), item 22.
May I please, your lordship?
My lord, on the last occasion, my lord had raised a query that the substantial questions of law were not framed properly. So my lord, I've filed the amended way of appeal with my substantial questions of law reframed. My lord will find the substantial questions of law in page 35.
Page
35, my lord. Of the amended memo appeal. May I read you, lord?
Tell me the gist of the facts.
So, my lord, what has happened is that the appellant as a plaintiff had instituted a suit before the learned trial court below, praying for declaration of right and interest over scheduled A property and eviction over B property. The trial court ruled in our favor. The appellate court also came to the similar conclusion when it came to the right title and interest over scheduled A property. But the learned appellate court reversed the finding regarding the eviction of schedule B property, inasmuch as the defendant respondent is my wife, and I had a duty under section 17 of the DV Act to give a shared household. Now, my lord, my contention is that neither before the trial court nor before the appellate court there was any adjudication or issue with regards to DV Act, with regards to domestic violence, any incident of domestic violence. The Honorable Supreme Court in a number of cases held that in order to give the protection of—
There was no proceeding
No, my lord.
on the DV Act pending.
My lord,
with-
the defendant had specifically admitted in a cross-examination that she had filed a DV case, but that was dismissed.
So no direction of
No, my lord.
relief of shared
No,
house.
my lord. And in fact, there's no pleading also for any kind of domestic violence in the entire pleading.
Thereafter,
Thereafter, my lord, the appellate court reversed the finding and said that and directed that although I have the right and interest over the property, but she cannot be evicted from the Schedule B property.
okay, now what are the substantial question of law which
So, my lord, number one is that whether the learned first appellate court was justified in reversing the finding of the learned trial court below by holding that the respondent number one defendant is not liable to be evicted from the suit land, and she has a right to residence over Schedule B property in view of section 17(1) of the DV Act without adjudicating framing issues as to whether the respondent number one was subjected to any act of violence as defined under section 3 of the DV Act to be treated as an aggrieved person under section as defined under section 2A of the DV Act 2005, more so when the respondent number one defended in the cross-examination in DW1 had candidly admitted that she had filed a DV case against the appellant plaintiff and the same was dismissed. My lord, now there is a judgment of the Honorable, two judgments in fact, of the Honorable Apex Court, which has categorically laid down that in order to give protection under section 19 of the DV Act, which is section 17, there has to be pleaded and proved allegations of domestic violence. So that settled position of law, my lord, was completely ignored by the learned appellate court. The second question, my lord, is whether the learned appellate court was justified in ruling that respondent number one was entitled to claim a right to residence in shared household over the suit property in view of section 2S of the DV Act without there being any averment connection thereto in her pleadings. Neither the parties, my lord, there are any pleadings with regard to any relief from under the DV Act. And the third question of law, my lord, is whether the learned first appellate court erred in law by reversing the finding of the learned trial court below, therein holding that the respondent number one defendant is not liable to be evicted from the suit land, and she has a right to residence over Schedule B property, when the appellant plaintiff had specifically pleaded that the schedule house was standing over Schedule A property, and the Schedule B land, which was—
No, what is third? Read again.
My lord.
Read the issue number 3 again.
Whether learned first appellate court erred in law by reversing the finding of the learned trial court below, therein holding that the respondent number one defendant is not liable to be evicted from the suit land, and she has a right to residence over Schedule B property, when the appellant plaintiff had specifically pleaded that the residential house was standing over Schedule A property, and the Schedule B land, which the appellant plaintiff had sought khas possession, consisted of fishery and various other zirats. Now, my lord, the house which is situated in is in Schedule A property. It was never a case that she may be evicted from the house, from the household property. The learned affiliate could misuse our pleadings, my lord.
No, appellate court held that she is entitled to shared household
My lord.
and
Over Schedule B
therefore
property.
granted declined the relief of eviction of the
Eviction.
defendant
My lord,
from Schedule B property.
B property, but my lord, Schedule
Over
B-
Schedule B property, there is no house.
No, my lord,
Okay,
the house is over Schedule A property.
then
My lord, these are the 3 points of law that.
yes,
Admittedly, my lord, the respondent is the wife of the appellant. Marriage solemnized in 1984.
we'll formulate the substantial
Yes,
question and call for the
It
record.
is correct that as of now, there is no residence order against any debate. We have not evidence. That's all.
Okay. Heard. Mr. S. Mitra, learned counsel for the appellant. Also heard Mr. P. Bhattakur, P.P. Bhattakur, learned counsel for the respondent. This appeal, this regular second appeal under section 100 of the Code of Civil Procedure, 1908, has been referred by the appellant, Shri Kamala Kanto Bhattacharjee, impugning the judgment and decree dated 28/7/2023, passed by the Court of Learned Civil Judge Nalbari in title appeal number 4/2023, by which the appeal filed by the, who filed the appeal? Appeal filed by the present respondent was partly allowed and partly allowed by modifying, partly allowed by interfering in the judgment and decree dated 24/1/2020, passed by Learned Munsif number 1, Nalbari, in title suit number 120/2014, in as much as though the right title and interest of the present appellant over Schedule A property as declared by the trial court was upheld. However, the trial court was, however, the present appellant was restrained from evicting the respondent from the Schedule B property on the ground that she is entitled to share household, being the wife of the present appellant. Stop. After considering the submissions made by learned counsel for both sides and going through the materials available on record, for following substantial question of law is hereby formulated in this appeal. Dash chamber में dictation लेना. Issue notice to no, since the appellant has, since there is learned counsel for the respondent has already appeared, the no need to issue formal notice to the respondent is there. This appeal is admitted. Let the records of the first appellate court as well as trial court be called for from the concerned courts. The registry to take steps for requisitioning the aforesaid records. Let this matter be listed after 4 weeks on receipt of the records. Please.
Like my lord.
Yes.
Lordship, may you kindly turn to page 56. This is the MP in order. The petitioner was a claimant who filed an application and claim petition before the tribunal seeking compensation because of he faced lordship one accident lordship, and thereafter his case was registered, and he lordship initially submitted his the deposition also, and thereafter also due to COVID outbreak lordship he could not appear, and the case was adjourned because of there were certain notifications also. And subsequently, lordship, that his engaged counsel took some time because of his illness. And finally on 6/12/2022, that your lordship will find page 56, that observations are there regarding the dates when he took adjournment. On that ground, lordship, this claim petition was dismissed, lordship.
Why you took adjournments earlier?
Because of his illness, lordship, because he was also suffering from some illness that was in itself mentioned in the claim petition also. Lordship will find claim petition at page 11, annexure 1. And relevant portion, your lordship will find page 13, serial number 11.
You were plaintiff.
Yes. He was the claimant, MSCT case, lordship. Motor accident
claimant.
claim tribunal.
Case was dismissed.
Because of his non-appearance, lordship.
Notice shall have to go
That I give up to your lordship, but
because insurance company may raise.
But a consistent view of this Honorable High Court is that claim petition cannot be dismissed for non-prosecution.
No, but suppose you do not produce the witnesses,
Okay.
it may not be dismissed for default. Because you are claiming from the insurance company mainly. So at least heard Mr. A. Ahmed, learned counsel. When it was dismissed,
That page 56, lordship, that 6/12/22.
who are you?
I'm the claimant.
Who was the
He suffered lordship injury.
injury?
Injury case, lordship, not death.
Okay, let notice go. Heard Mr. A. Ahmed, learned counsel for the petitioner. This application under section 115/2, 115 of Code of Civil Procedure. (1908) has been filed by the applicant by the petitioner impugning the order dated 6/12. It is 115, 5 or 2.
227 is also there.
No. Under what provision it has to be? It cannot be simultaneously under. You choose, because if you choose 115, the
227.
question of limitations,
227 will be there. Only 227, Lordship.
it cannot be under both jurisdictions.
227 will be there.
It has to be treated as an application under 227. Though this application has also been, has been filed under section 115/115 of this Code of Civil Procedure, read with Article 227 of the Constitution of India. However, considering the facts stated in the application as well as the impugned order, this court is treating the instant application to be an application under Article 227 of the Constitution of India. The petitioner has, in this revision application, impugned the order dated 6/12/2022, passed in MSC case number 198/2018 by the Motor Accident Claims Tribunal, Gwalpara, whereby the aforementioned MSC case was, which was registered on the basis of a claim application filed by the petitioner, was dismissed on failure of the claimant/present petitioner to adduce evidence in support of his claim before the claims tribunal.
And for cross-examination.
Whose cross-examination?
Cross-examination of the PW1, that is the claimant.
As well as to present himself for cross-examination by the respondent side. So, issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual vote within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Public.
We need some more time. We'll take instruction about the residence of the respondent 1 and 2, Lordship. Once we have corrected their address, and even then we could not serve notice, Lordship. Some more time may be granted, Lordship, in this matter.
Heard Miss R. Chaudhary, Learned Counsel for the appellant. Also heard Mr. S.P. Sharma, Learned Counsel for respondent number 3. Learned Counsel for the appellant submits that Learned Counsel for the appellant prays for some more time to get the proper address of respondent number 1 and 2, as till date they are unable to trace
Already service report not found.
trace out the proper address, as in the address known to them, the notices could not be served, and have written with an endorsement that addressee not found. Considering the submissions made by learned counsel, for the appellant, the prayer is allowed. Let this matter be listed after 4 weeks. After 2 weeks.
During this case, we have filed 3 applications for substitution of the respondent number 7. There's some delay. So the continuation application is also being filed since 3426 of 25 IA.
3426. Delay condonation is
3427.
27.
27. How much delay is there?
Delay is
No objection, Lordship.
Okay.
I'm appearing for respondent number 8, Lordship.
Heard Mr. B.K. Das.
SP Chaudhary.
Heard Mr. S.P. Chaudhary, learned counsel for the applicant. Also heard Ms. R. Chaudhary, learned counsel for respondent number
8, Lordship.
8, as well as Miss P. Gandhia, appearing for respondent number 226.
The death of 1.
226. Who is appearing for 1?
One, I have to check the office note whether the service is complete or not.
1.2 to me appear hona.
Who is 1?
1.1 is the legal error of respondent
Respondent
number
number 1, the
1.
original
So they
respondent
may
number
be asked to take instruction whether they can appear for respondent number 1.1. She is Srimati Meena Dekka, sister of respondent number 1.2.
Name has been shown. Lordship, in the cause list, C. Sharma is appearing. C. Sharma for respondent number 1A to 1F.
नाम चेक हो सकता है बोलो तो
1.1.
The last, C. Sharma.
No.
Okay, in this case, earlier there are other sets of advocates. They have newly engaged. I am also newly engaged for respondent number 8. So respondent number 1.1 is the sister of 1.2.
No, but who is appearing for other 1.2, 1.3?
Is appearing.
No, they are appearing for 2 to 6.
6.
So 1 no is appearing.
Lordship. Then we have to check the office note.
No, in the Lordship, in the cause list, the name of the concerned counsel is there. Lordship. Miss C. Sharma is appearing. Probably they have withdrawn the bill. C.
C.
Sharma, the last name in the list of advocates.
1A to 1F, yes. Who is she, Sharma? Now what is to be done?
Services.
Interlocutory application, your Lordship can allow. We have no
The
objection
question of
on the question
limitation.
of, whether they have any objection. 1.1 or.
Because otherwise the whether they are required to be heard.
Worship, since the discretion of the court and they have already
No,
given
no.
their this.
My question is, the appeal has been abated against
This one number
respondent
seven.
number one. Respondent number one,
Seven, Lordship.
Seven died.
who died?
Seven,
Seven
respondent number
died,
seven, not one.
One was otherwise appearing.
Yes, Lordship.
Substituted and the substituted legal heirs are appearing through the learned counsel C Sharma. So this application for substituting the respondent number seven.
Okay. Since the cause list shows reflects the name of Miss C Sharma as engaged counsel for respondent number 1.1 to 1.5. The and since the said counsel is not present today, this court is not inclined to issue fresh notice to respondent, the aforesaid respondents. This application under Section 5 of the Limitation Act has been filed by the applicants praying for donation of delay of how many days?
349 days, Lordship, from the date of
564 days in filing the application for setting aside abatement
31.
as well as substitution application on the death of whose death?
Respondent number seven, Lordship. In paragraph 5 of the delay petition, we have made a mention with regard to that.
But in the cause title, you have mentioned
No,
that
there is inadvertent mistake is there, Lordship. I'm sorry. for
not
that.
inadvertent,
April.
that is,
I'm sorry, it's a
you have-
copy paste, Lordship, I'm sorry for
you have killed
number
appellant number
Yes,
2.
yes, I've seen that I marked it, it's wrongly mentioned. In the prayer portion, we made a mention for substitution of respondent number seven, Lord. Legal heirs of the respondent number seven. There are page 9, Lord.
In civil cases, such mistakes are not
Exactly,
condonable.
Lord.
condonable.
Exactly.
But though other side is not contesting, therefore we are not pressing.
Plaintiff Lordship, so you want the early disposal.
Prayer is there, Lord. In the prayer portion, we have made a mention with regard to that.
क्या लिखा? The death of respondent number 7, who died on 31/10/2023. Learned counsel for the respondents submits that they have no objection if the delay in filing the application for setting aside abatement and substitution of respondent number 7 is condoned. Considering the submissions made by learned counsel as well as considering the ground shown in the application which caused the present applicant, which occasioned the delay of 564 days in preferring the application for setting aside abatement and filing of substitution application to be sufficient cause, the delay of 564 days is hereby condoned, and this interlocutory application is allowed according to this contract. Setting aside abatement.
3428, sir.
Heard Mr. S.P. Chaudhary. Same councillor naam likhe. This application under order 22 rule 7,
Nine.
rule 9 of the Code of Civil Procedure has been filed by the applicants praying for setting aside of abatement of the appeal on death of respondent number 7 on 31/10/2023. Stop. The learned counsel for the respondents have raised no objection to the prayer of the petitioner. Stop. Considering the submissions of learned counsel as well as grounds stated in the application, the prayer for setting aside of abatement of the appeal on death of respondent number 7 against the said respondent is hereby allowed. And this interlocutory application is disposed. Substitution. Not so and so. This application under order 22 rule 4 of the CPC has been filed by the applicant / appellant in connection with the connected regular second appeal number 6/2016, praying for substituting the legal heirs of deceased respondent number 7 in the memo of appeal of RSA number 6/2016. Learned counsel for the petitioner has submitted that the respondent number 7 had expired on 31/7,
3110 Lord,
31/10,
2023.
2023. And though the appeal against him got abated due to operation of the law, however, by order dated 21/11/2025 passed in IA number 3428/2025, the said abatement was set aside. He submits that the legal heir, who are the legal heirs?
Paragraph 5, Lordship, page number 8.
He submits that the legal heirs of the deceased respondent, namely Shri Satyajit Rajvanshi and Shri Jiban Chandra Rajvanshi, may be accordingly substituted as respondent number 7.1, 7.1 and 7.2 in the memo of appeal of the connected regular second appeal. The prayer is not opposed to by the learned counsel for the respondents. Hence, same is allowed. You will file
I'll file the amended, or the registry may correct. The amended, I will submit the amended.
the
Posted.
applicant is directed to file an amended cause title of the memo of appeal in the connected regular second appeal, showing name of Shri Satyajit Rajbanshi as substituted defendant, respondent number 7.1, and name of Shri Jiban Rajbanshi as substituted respondent number 7.2 in place of deceased respondent Srimati Kanchan Deka. The registry to list the regular second appeal after 2 weeks.
To correct the CIS system also, Lord.
The registry shall correct the CIS system accordingly. Correct the data in the CIS system accordingly.
Notice is required to be served as because I will file my wakalat number for them
In
the appeal, Lordship.
that has
So
to
that
be
after-
passed in
Yes, cost title is submitted.
after cost item
Cost item.
correction.
My submission may be recorded so that in future no notice is required to be served upon them.
When the matter will be listed, then I can file the wakalat on the particular date.
No.
In the RSA, it will be passed
Exactly,
on the
RSA.
next day.
Lordship, obliged.
Yes. Twenty-eight file is misplaced. They are finding it out. We'll call it as next item. 29.
As per office note dated 35/2025, Lordship, notice has been issued from respondent number 4 for user process. There is no service report. But this is a long pending matter from 18 matter, Lordship, and he's the owner and driver. So I would like to take fresh step, Lordship, for paper publication. He's a resident of Bangalore,
Okay, then all India paper.
Lordship.
Heard Mr. R. Sharma, learned counsel for the appellant. Also heard Mr.
Yes, Islam.
S. Islam, learned counsel for respondent number.
He's IA, Lordship.
I am my lord. I am
But
number
respondent
95,
1 to
Lord.
3, AR Agarwala is appearing.
None has appeared for other respondents. Learned counsel for the appellant submits that since the service report in respect of respondent number 4, in respect of notices issued to respondent number 4 through post has not yet been received back. And since the respondent number, the address of the respondent number 4 is shown in the district of Bangalore, in the state of Karnataka, the appellant may be allowed to take steps for issuance of notice upon respondent number 4 through substituted mode of publication of the notice in the newspaper. The player is allowed. The the appellant shall take steps for issuance of notice on respondent number 4 by publishing the same in the newspaper, which is widely circulated in the area where the respondent number 4 has been shown to have resided last. Resided as per his given address within 15 days from the date of this order, returnable on
Last month of January, Lordship.
30th January. List accordingly. You are in cross objection is there.
Cross objection is there and IA is also there, Lordship.
What I Eh, You are for,
No, I am for the mother of the deceased, my lord.
you are not a party.
That I was not made party to the my lord during the pendency of I number 1765, my lord, oblique 18. The mother died, my lord. Thereafter, we have filed an IA, number 95/22, my lord, impleting the legal hair of the mother.
There is an order, lordship, that this IA will be heard in on final hearing, lordship. There is an order.
No. Unless, how impleachment petition can be heard in final hearing?
His order for this court, lordship.
Suppose matter is finally heard and thereafter court comes to a finding that impleachment is necessary. This matter cannot be heard. This has to be heard now.
I have no objection.
No, it was actually in a kind rejected. In a manner it was rejected. The last order is taking into account the above facts. The entitlement of the applicant's hearing shall be decided at the time of final hearing of the appeal.
Is number 9 and 10, my lord. I have submitted annex, my lord, legal hair certificate, my lord, of I 95/22, my lord.
Who? Mother of
Mother of the deceased, my lord. Deceased is my lord Akbar Hussain Mullah. He was the deceased, my lord.
You have any objection?
No, lordship.
No, but mother has not filed MAC appeal before the MAC case before the tribunal.
I have case number 2124, my lord. I have filed an implead petition and I was impleaded
Where?
before the honorable tribunal, MACT. Case number 20 to 24, my lord. Impleadment petition under Order 1, Rule 10 of the CPC, my lord. I am 95, my lord.
This is the petition. Where is the order?
My lord, page number 27 to 25 to 26, my lord. The order of the honorable tribunal, my lord. Page number 25 to 26. I was impleaded, my lord.
During the pendency of the
MAC.
MAC case.
Thereafter, my lord, I was granted award. That is 10,41,000 something, my lord. Page
Then
number-
you should have been made party. If they were impleaded during the
Page number 32, my lord. I was granted compensation, my lord, by the honorable tribunal. my lord. Page number 32. My lord, para 18.
what is your name?
My lord, Rokia Bewa,
Rokia.
Bewa, mother of the deceased.
No. Mother was given,
Yes, my lord,
but mother expired.
expired, my lord.
Mother has, after expiry of mother,
Yes, my lord. My Ashik Iqbal, the applicant are three daughter three sons, my lord.
Yes. Yes, Mr. Sharma.
Lordship, the- allow the eye or it can be heard finally, Lordship. To you, Lordship.
We are allowing it.
Lordship.
Heard Mr. Inai, heard Mr. S. Islam, learned counsel for the applicant. Also heard Mr. Who is respondent number 123?
Number 1, 2, 3 are the wife and children, Lordship. Begin.
Also heard Mr. R. Sharma, learned counsel appearing for the respondent number,
For the insurance company, Lordship.
respondent insurance company. This interlocutory application has been filed by the applicants, namely 1, 2, 3, 4. नाम लिखिए No, namely one, two, three, four, five, 6. Praying for allowing them to be impleaded as it should be as impleaded as respondents in this case. Being heir of late Rokia Begum,
Bewa, my lord.
Rokia Beva, who was also granted a share of compensation awarded by the Impune Judgment and Award. Stop. Learned counsel for the insurance company, respondent insurance company, does not raise any objection to the said prayer. Stop. Considering the fact that Rokia Beva was one of the claimants to whom a share of awarded amount was directed to be given by the Motor Accident Claims Tribunal. Which motor accident
Three,
claims?
my lord. Motor accident claims tribunal number 3, Kamrup Metro.
Number 3, Kamrup Metro, by the Impune Judgment and Award, by the Judgment and Award, which has been impugned in the connected MSC appeal. This court and since the present applicants are the legal heirs of Rokia Beva, this court is of considered opinion that they are necessary parties in this appeal, and therefore their impleadment application is allowed. You will file amended the appellant insurance company is directed to file amended cause title in the connected MAC appeal by showing the names of present applicants as respondent number
Up to 10 Lordship.
5 to 10. This interlocutory application is accordingly disposed of. List the connected MSA appeal after rectification of, after submission of the amended cause title by the appellant after 2 weeks, after 4 weeks. Huh? What? No, after 4 weeks on 28/1. 28/1 is in the main
Okay.
same date. After 4 weeks, लिखित है. On instead of 28/1, instead of after 4 weeks, on 28/1, 2026.
अब ले लो. Your Lordship. Lordship, in this case, I was directed to take steps through paper publication. And accordingly, I have taken this step, also filed the affidavit, Lordship. Affidavit is also on record. So service is complete, Lordship. Respondent 1 and 2.
How many respondents are
2
there
respondents.
against both the respondents?
Lordship. So, court order.
Heard Mr. R. Sharma, learned counsel for the appellant, who submits that in pursuant to the directions of this court, the appellant has taken steps for issuance of notice upon respondent number 1 and 2 through paper publication. And the notices have been accordingly published in the newspaper. 2 daily newspapers, namely Neumia Barta on 14/11/2024, as well as in the Assam Tribune on 14/11/2020. 25, both are 25. In support of its submission, he further submits that the appellant has also filed the affidavit in compliance to that effect before this court. I have gone through the affidavit filed by the appellant, as well as the newspaper annex therewith, in which the notices to respondent number 1 and 2 have been published. In view of the publication, what was the date? The return date?
14/11/2020. Publication date.
Today's date. Since the date of appearance mentioned in the said notice is today's date, that is 21/11/2025. The notices are held to be duly served on respondent number 1 and 2. No one has appeared for the said respondent. The records are there. And since the records are available, this case is ready for hearing. Let this case be listed for hearing after 2 weeks on the date to be fixed by registry.
ले लो.
May please, Your Lordship. In this case, if regular second appeal service already complete, LCR received, then it was fixed for hearing in usual column, Lordship. and we prepared one IA for early hearing. In the early hearing also notice issued. All respondents notice served except respondent number 1. So we want to take justice service on respondent number 1. My learned friend is appearing for 2.1, 3 and
Appearing for 2, 3, 4, 4. I have filed the Wakalatnama, but I will be appearing for all the respondents. Your Lordship. The
One.
Wakalatnama 1 also, including 1. Just the difficulty is, Your Lordship, that we have received the court notice regarding the case number, but we have not received any petition with the copy, Your Lordship. May a copy of the petition be granted to us of the main unit, of the main, along with all the IA also, Your Lordship.
Now main will be heard.
Yes, Lordship. Just for reference, Your Lordship, you other.
when they appear, Lordship can consider my IA. This is for early hearing.
We'll fix a date. I is there.
Yes, Lordship, 853.
853.
To that effect, Your Lordship, I am completely unaware about the contents of the case as we have not received any petition. That would take some time for hearing on this IA also. We require some time to prepare, Your Lordship.
Early hearing of objection.
Indeed, Your Lordship, because we have to go through the file and prepare our things, Your Lordship. Just any date may be fixed, Your Lordship.
Next week, any date, then Lordship may consider my IA, then fix it in the 2026.
Ms. R. Chaudhary, Learned Counsel in main appeal. Ms. R. Chaudhary, Learned Counsel for the appellant. Also Mr.
TL Oscar.
T.L. Oscar, Learned Counsel, who submits that he will be appearing for all the respondents and would be filing the Wakalatnama in very shortly
I have filed
for
the
those
other-
respondents for which he has not yet filed. Stop. This matter is ready for hearing. List it for hearing in its usual course. RSA in usual course,
There
today
is
I am mentioning.
Lordship, there is already an order for usual course. Then I filed this IA. In IA notice was issued, then my learned friend.
Liz,
This IA.
list this, no, RSA likho. List this RSA for hearing on a date fixed by registry, subject to the outcome of IA number 853/2025. In IA number 853/2025. Heard Ms. R. Chaudhary, Learned, same order. Parties appearance or like a same order. List this interlocutory application
2nd of December. it was.
on 2nd of December.
That's
Yes. That I am not reflecting.
obliged.
Much pleasure.
Item 32.
Lordship, the service report has returned back as insufficient address, Lordship. So Lordship, kindly, we may be permitted to take a fresh step.
By
Lordship.
which mode? By by speed post.
Speed post, Lordship.
Okay. Heard Miss, what is the name?
See, Saikya.
C. Shaikya, Learned Counsel for the Learned Counsel for the petitioner. On perusal of the office note dated 18/11/2025, it appears that notices issued to respondent number 1 and 2 have returned without service. Learned Counsel for the petitioner prays for allowing the petitioner to take fresh steps. Prayer is allowed. The petitioner shall take fresh steps for issuance of notice upon respondent number 1 and 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 15th of December.
Lordship, there is an interim order, Lordship, it may continue.
The interim order shall continue till next day.
34.
May please your lordship, as per office note dated 13/8 of 30th/10/2025, answer notice has returned back in respect of respondent number 2, lordship. So we may be permitted to take fresh steps after ascertaining the correct address of respondent number 2, lordship.
Heard Miss P.
P. Devi.
B. Devi, learned counsel for the petitioner, who submits that in view of the office note dated dated 30/10/2025, whereby it has been reflected that notice issued to respondent number 2 has returned without service with a endorsement inverted comma addressee out of station RTS inverted comma because comma the petitioner may be allowed to take fresh steps. So if the prayer is allowed, the petitioner is directed to take fresh steps by fresh steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Please check. Returnable on 18th of December. The interim order shall continue. Where is the interim order?
As per order dated 13/8/2025, lordship, the further proceeding of TS number 39 of 2021 pending.
The interim order shall granted earlier shall continue till next.
3 p.m.
45.
May please your lordship, and take official with the 18/11/2020, no edit card or no answer notice has been returned in respect to respondent 1 to 5, my lord. I may be allowed to take fresh steps on speed post as well as those service number.
Heard Mrs. Roy, learned counsel for the applicant. On perusal of the office note dated 5/8/2025, it appears that notices issued to respondent number 1 to 5 have returned without service. No, have not yet been returned. Whereas upon 6,
It's refused to receive the notice.
due service has been held. There is an order.
Refused to receive the notice, edit card not answered notice.
Yes, has completed. There is an order. In view of the aforesaid office note, regarding 6 echo likhibo nalage. 6 echo likhibo nalage. Has not yet returned. Stop. In view of the office note, the petitioner is directed to take fresh steps for issuance of notice upon respondent number 1 to 5 by speed post as well as by usual mode. Usual mode within 7 days from the date of this order, returnable on 16th of December. The petitioner is also allowed to take steps additionally for service of notice upon respondent through Dasti mode. Stop. In the event the notice is served by Dusty Mode, the petitioner shall submit an affidavit in compliance to that effect on the next date fixed, list accordingly.
36.
In this case, I have filed one interim application with a prayer to allow the opposite, with a prayer to direction to the opposite party to allow the applicant to meet their son Miller. I have filed guardianship case and that was rejected and but visitation right was given. But the opposite party is not allowing to meet my son Miller. Although there was an order of the London trial court Miller. Notice was issued and
Where is the order?
Your Lordship, can say 15/9/2023, page 7.
7 in IA.
Actually, last part, the petitioner being admittedly the father of the minor, namely Anshuma.
Your father? Okay.
And your Lordship may kindly also say the page number 17, my lord.
Which order you have impugned in the?
Order is 17/2024, my lord.
This order has been impugned.
Yes, my lord. And in 17/2024, in paragraph number 18, it was again reflected. However, the petitioner shall continue to visit his child as per the relevant direction passed earlier in the present case.
But notice has not been served.
Take its steps, my lord. In the appeal, advocate has appeared, my lord.
Appeal some. Records have arrived. How if you heard Miss S. Roy, learned counsel for today only this one is listed. Learned counsel for the appellant. No one has appeared for the appellant. No one has appeared for the respondent. Release this matter after 2 weeks for hearing. In this case, what is your prayer? No, that has been already allowed by the trial court. Then you have to complain before the trial court. We'll dispose it of
The direction.
with a direction that you may approach before the trial court that there has been violation of its order. Heard Ms. S. Roy, learned counsel for the applicant. Also heard none has appeared for the opposite party, though name of Mr. Who is the counsel? Miss A. Hussain has been reflected in the cause list as engaged counsel for the opposite party. This interlocutory application has been filed by the applicant seeking compliance of the order dated 15/9/2000. Compliance of the order dated 1/7/2023. Okay. What is 15/9?
15/9 is the interim order, my lord.
Where is your prayer?
Page number 5, my lord.
Seeking compliance of the order dated 15/9/2023 and 1/7/2024 passed by the passed by learned Principal Judge Family Court, Dhubri in FC, Miss within bracket G, case number 5/2023, whereby the respondent was directed to allow the petitioner to visit his child in spite of rejection of the application of guardianship filed by the present petitioner. So it appears that while disposing of FC Miss G case number 5/2023, the Court of Learned Principal Judge Family Court Dhubri, while dismissing the prayer for guardianship in favor of the guardianship of the child to the present petitioner, has categorically stated that the petitioner shall continue to visit his child as per the earlier direction passed by the court. Hence, this court is of considered opinion that no fresh direction is necessary in that regard, as the family court has already allowed the present petitioner to meet the child in spite of dismissal of his guardianship application. So, if there is any violation of the direction of the trial court, the petitioner may approach the trial court seeking enforcement of its order. This interlocutory application is accordingly disposed of.
47.
I for condonation of delay. The services as per office note dated 10/11/2025. The respondent number 1 to 3, 6 and 8 not served. Flag X.
What is to be done?
Substitute for publication.
Okay. Not Mr. L.K. Gowai. Learned- Sorry, L.K. Bora, learned counsel for the applicant. Learned counsel for the applicant. By on perusal of the office note dated 10/11/2025, it appears that notice issued to respondent number 1, 2, 3, 6, and 8.
It has refused by Sean. The
6.
father's name of the addressee is not.
Correct. Has not been served. You take fresh steps with proper.
For 8.
For it.
Other respondent might not maybe person necessity order for paper publication, substitute service. That they are,
But father's name have to be correct.
it's it.
Stop. Learned counsel for the petitioner allows that the learned counsel for the applicant prays that the applicant may be allowed to take steps for issuance of notice upon aforesaid respondents through substituted mode of paper publication. The prayer is allowed. The applicant is directed to take steps for issuance of notice upon the respondent number 1, 2, 3, 6, and 8 through paper publication by publishing the notice in 2 widely circulated newspapers.
National paper, because outside of state, this, as per report.
In the widely circulated newspapers circulated widely in the area where the addresses of this above mentioned respondents are mentioned. So the steps shall be taken within 15 days of the date of this order, showing date of appearance in the notice as 28th of January. List accordingly.
Most of it.
Item 48. May it please your lordship. In this motor accident appeal, my lord, I am the claimant respondent. The insurance company has filed the appeal. Your lordship has already admitted the appeal, but the appellant did not press for stay or stay. Petition was filed, but it was not pressed. If it is pressed, usually your lordship grants stay subject to payment of 50%. Perhaps for fear of that, and they have not pressed. Now, my lord, this my Bakija application is not accepted on the ground that it is sub judice before this honorable court.
No,
My lord.
that I will clarify. You can go for execution.
And they are not accepting, my lord, on the plea of pendency of appeal in this honorable court.
No, you have to
Unless some-
convince them.
I'll certainly go, my lord. Kindly make an observation that the certificate officer is free to execute the award. That observation will do, my lord,
This I is for
for this, my lord.
that purpose. Yes, Mrs. The pendency of the appeal would not operate as a bar in execution. This observation I will make. You have anything to submit,
Was it 50% also?
but you have not.
But now, because the stay is there and today it is listed also.
Stay application is there,
1361.
1361, so. Then you are not pressing this.
No, not pressing.
34,850. This heard Mr. S.P. Shah, sorry, heard Mr.
KK
A.K. De Learned, K.K. De Learned Counsel for the applicant. Also heard Mr. S.P. Sharma, Learned Counsel for the respondent insurance company. Learned Counsel for the applicant prays for allowing the applicant to withdraw the instant interlocutory application. The prayer is allowed. This interlocutory application is dismissed from withdrawal. This 1631
1361.
heard Mr. S.P. Sharma, Learned Counsel for the applicant. Also heard Mr. K.K. De, Learned Counsel for respondent number
1 and 2.
1 and 2 / claimants. This application under Order 41, Rule 5 of the CPC has been filed in connection with the connected MSC case number, MSC appeal number 167/2025 by the applicant insurance company praying for stay of execution of the judgment and award dated 17/1/2025 passed by the Motor Accident Claims Tribunal number 1 Kamrup Metro in MSC case number 2640/2019, whereby the applicant insurance company was directed to pay how much was the award?
14 lakhs.
Directed to pay an award, a compensation of
14,65,984.
14,65,984 with an interest
9%.
at the rate of 9% per annum. Stop. Learned Mr. K.K. De, Learned Counsel for the appellant, Learned Counsel for the respondent / claimant submits that he does not have any objection to the prayer made by the applicant, subject to the condition that the applicant may be directed to deposit 50% of the awarded compensation amount before the registry of this court. Stop. Considering the submissions made by Learned Counsel for the purpose, this interlocutory application is allowed, and the execution of judgment and award dated 17/1/2025 passed by the Motor Accident Claims Tribunal number 1 Kamrup Metro, Guwahati in MSC case number 2640/2019 is stayed during the pendency of the connected MSC appeal number 167/2025, subject to the condition that the applicant insurance company shall deposit 50% of the awarded amount before the registry of this court within
6 weeks.
6 weeks from the date of this order. Stop. In the event of such deposit by the insurance company, the registry shall, after proper verification,
Lordship, we have objection in that because Lordship, the main ground we have taken here is the violation of policy condition and the requirement of owner is required. And
then
so-
you file an application.
Yes, that will be better.
My lord,
Last
her
line cut.
husband has died, my lord, she has not received any.
Because we are not liable
No
to pay,
money.
Lordship.
No.
Last line.
The learned tribunal has discussed everything, my lord, elaborately discussed. The Supreme Court judgment has been relied on.
Also, let them file a I.
You
because
file an
our
I. You file an I for release of the amount. Release this matter. The
Also, in the main appeal, Lordship, the service of respondent number 3 is not complete. So we may be allowed to take steps by newspaper, Lordship.
Heard Mr. S.V. Sharma, main appeal. Heard Mr. S.V. Sharma, learned counsel for the appellant. Also heard Mr. K.K. Day, learned counsel for respondent number 1 and 2. On perusal of office note dated 11/11/2025, it appears that notice issued to respondent number 3 and 3 has not been served. Hence, he submits that hence learned counsel for the petition appellant submits that the appellant may be allowed to take steps for issuance of notice upon respondent number 3 by substituted mode of paper publication.
Vernacular newspaper, Lordship, because the address is of Kamrup.
The prayer is allowed. The applicant shall take steps for issuance of notice upon respondent number 3 through newspaper publication by publishing the notice in the 2 widely circulated newspaper. I am not specifying widely circulating newspaper, within 15 days from the date of this order. Stop. The date of appearance in the notice shall be shown as 28th of January 2025. List accordingly.
Obliged, Mr.
39 and 40.
These are connected matters, Lord. We have file an IA for fixing an early date of hearing, Lord. If the Lordship would kindly have,
Your Honor, IA number 933 is to be disposed of first,
Ah.
Your Honor. That is for substitution of respondent number 2. He has died. In respect to respondent.
You are appellant.
no, I am
the
respondent. No, that can be, what has happened, last occasion, Lord, both these appeals are connected. Lord, in one of the case, 90, the appellant is the husband, and in 91, the appellant is the wife. Lord, husband and wife, the respondents are same. Lord, there was a substitution applications filed jointly, separately for both the cases. One was allowed on 23/6/25. This 19, application number 933 has not been disposed of. So, Lord, this can be disposed of, Lord. And while
We'll file the amended memo of parties. After that,
Lord, they have not done so far, Lord. The order is passed on 23/6. Lord, that's why.
933.
you know, in respect to 1072, we have already filed. We have also filed the amended memo of parties. But in respect to 933, it is to be disposed of, Your Honor.
Lord, can dispose it now. Lord, that was my submission also.
Thereafter, the applications 3628 and 3629 can be heard, Your Honor.
But there I have some other submissions to make. Lord.
What is the matter?
Lord, there the appeal has been dismissed. They have come then secondly. My Lord, will kindly have a look at order dated 23/6 in RSA 90.
There are 2 RSS.
90 in RSA 90, my Lord. First one, item number 13. Lord, my friends are appellant, Lord. They should not have any objection regarding early hearing. It's an appeal of
No,
2017.
no. He is only stating that
No, no, he's saying
service,
that this, Lord, parties
service,
have represented, there is no issue as regards service. Lord, what has happened while the, in RSA 90, Lord, while disposing, Lord, the same order has to be followed in 91, but that was not done. That's why 933 remained pending.
okay, we'll do it today.
Yes. And now, Lord, have a look at RSA 90, Lord, for a
Yes,
order dated 23/6.
yes.
Mr. R.B.B. Lamkang appears on behalf of the newly employed, taking into the above services come accordingly is the matter for hearing in junior court. Liberty is given to both the parties to file an appropriate application for early hearing. Lord, we have been given, and they being appellant, they have no hurry. Lord, my applicant number 1 is a 88 years old lady, Lord.
suit is going on from 2000.
We'll fix it today. Heard Mr. Z, what is your name?
W Hawk on behalf of Mr. Jed Mukit.
W. Hawk, appearing on behalf of Mr. Z. Mukit. This is in IA number 933 in RSA 91. This application, this interlocutory application under order 22 rule 4 of the CPC has been filed by the applicant for substituting the legal heirs of the deceased respondent, namely respondent number 2, namely Shri Bakul Kumar Gogoi, who had expired on 25/10/2022. 22, then it is abated.
We have not, because we had informed them. That's how they came to know.
But by operation of law, it got abated.
That
There has to be an application for setting
Lordship
a.
has allowed that application for substitution, because it is we who have informed them under order 10 on blood. That's how this application has come.
But where is where is the substitution application in the other
They
case?
say, but there is that has been allowed by order dated 23/6.
In which case?
In RSA 90. There is an I.
1072 I.
107.
107 some.
072.
You have not filed any setting aside of abatement application.
No, Lordship, because on the last occasion, it was informed by them.
No, he may be informed by anybody. But suppose somebody dies, then by operation of law, the appeal abates against the deceased respondent.
We have also considered because otherwise it would have been.
But there has to be an order.
Perhaps in this case where we have informed that, I understand what has fallen from your lordship. Since only thing that this order was not followed in 933, otherwise you.
Unless abatement is set aside.
Correct.
Though procedural requirement, but that has to be followed.
But otherwise also they are the legal heirs. I understand what has fallen.
So the application under order 22 rule 9 is not required. Is that your submission?
My submission would be even in substitution petition, your lordship can consider this if I don't object to it. Because it is we who have informed them, and according to them and what from the date of knowledge or information, they have filed the application. That is what they had contended. The parties were represented in that.
What is our order 22 rule 9? Give it. You have a copy of CPC. Whether an application is required. A common application would have, but
since appeal are different, if they plead in the application itself regarding that can
yes,
be considered
that can be considered.
so that they have pleaded that way, that because we have informed them, that's why they are.
What is order 22 rule 9?
Where a suit abates is or dismissed under this or no fresh suit shall be brought on the same cause of action.
Whether an application is necessary for setting aside abatement. Mm, Otherwise, against respondent number 2, suit will abate, the appeal will abate, they cannot claim any relief against them.
But in the other case, my lord, the substitution order has been passed, my lord.
No, other case is a different case.
Different case, but they are all same defendants, same parties.
You file an application.
My lord, can-
These two are to be heard together.
You can fix a date for hearing, my lord. And in between they file it, my lord, that would be a procedural.
This will be again defective.
You can take it up next week, my lord,
That we can do.
Wednesday, Monday, my lord.
They have to file an application. क्या लिखा? ये लिख ले. 933 expired on 25/10/2022. Stop. And same has reported to them. Same has come to the notice of the applicant only on 10/3/2025. So it appears that apparently due to expiry of limitation period for substituting the legal heirs of respondent number 2, who had expired on 25/10/2022, the appeal against the said respondent has abated. It also appears that no application has been filed by the applicant under the proper provisions of law, or for that matter, any prayer has been made for setting aside abatement, setting aside of the abatement of the appeal against respondent number 2. Under such circumstances, the learned counsel for the applicant prays for some time to file an appropriate application for setting aside of abatement, as well as you have to file for condonation of delay, as well as for condonation of delay in filing the said application. The prayer is allowed. Let this matter be listed next week. In the next week only. When?
When it did. Wednesday, my lord.
Wednesday, okay. On Thursday. Thursday. I number 1072 Kia Celia.
That has been, that has been disposed of. There in the other case, my lord, it has been allowed. Okay. Would this application come up that day only for the early hearing?
Early hearing, you have filed only one application.
Two, in that case also.
In IA number 3628/2025. And in IA number, one more IA is
3629.
3629 of 2025. Separate order hobo. Order separate hobo dotate. Heard Mr. R. Dubey, learned counsel for the applicant. Also heard Mr. Mr.
W Hawk.
W. Hawk, learned counsel for the respondent. This application for this interlocutory application filed by the present applicant, praying for expeditious hearing of connected regular second appeal may be listed on next Thursday, 27, and same shall be decided after the disposal of prayer for substitution of legal heirs of respondent number 2 in RSA number 91/2017. Within bracket IA number 933/2025. List accordingly.
Alright.
Forty-one.
May I please your lordship, section 5 application, your lordship. This came up your for the first time, your lordship. Lordship may issue notice, your lordship, in this.
Heard Mr.
S.A. Hussain, your lordship.
S.A. Hussain, learned counsel for the applicant. This application under section 5 of the Limitation Act has been filed by the applicant for condoning the delay of 1,212 days in preferring the connected matrimonial appeal. Issue notice to the respondent. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
42.
May it please your lordship. But this IA is for condonation of delay of only 2 days, my lord, in preparing a regular first appeal. Delay be condoned, my lord. Appeal be registered.
Notice will have to go.
Only 2 days, my lord. My lord, thing is that against the counter claim also there was a delay of 2 days, my lord. That was also condoned, my lord. This is an appeal against the judgment and decree. Against the counter claim, there was a delay that was condoned, my lord. 2 days.
But what is the procedure?
But the only thing is that, my lord, we were bona fide of the belief that, my lord, appeal was preferred within 90 days. But the office calculated saying that only 2 days delay was there. So that can be condoned, my lord, because ultimately it's a regular first appeal, statutory appeal is, my lord. My lord, may kindly peruse that order, my lord. It's from the same judge.
No, whether he has a right of audience or not. The other side.
It's the discretion of the court, my lord, because whether there is a delay or not, ultimately, my lord.
So you are saying that as the delay is of only 2 days, notice may be waived.
Yes.
That is your main contention.
Yes.
For 3 days, it may be waived or not.
No, it will be up to the discretion of the court, my lord. My
So
only submission.
for waiving notice, till what point of time, what is the limit for the court?
Had there been any kind of factual aspersions on our part that there was a laches or negligence, then, my lord, it could have been that the other side could have got an opportunity of making a submission that yes, there was negligence or delay, laches on our part.
No, I am on different. Has some right has accrued
Definitely, my lord.
on the other side.
Definitely, it's an interlocutory application, man. So definitely they will have an opportunity. They will definitely get an opportunity, but subject to a lordship's discretion also, madam. Since
No.
it's a case of only 2 days delay.
Notice has to go.
Madam. But then again, madam, the same delay in the connected appeal, madam, that was condoned, madam.
Without hearing you.
Yes. Same judgment. I'll leave it to Lordship. Because there was some urgency involved.
No, you show me the right course.
Then my lord will fix it on Monday or Tuesday, my lord.
That even
Yes.
waiving notice. Waiving in,
Yes.
while considering my queries are
Yes.
whether by lapse of limitation, any right accrues to the other side. Then whether without hearing him, even 1 day delay can be
My lord.
condoned.
I'll satisfy on that.
Okay. Heard Mr. S. Das, learned counsel for the applicant, who submits that, who prays for
1 week time.
1 week time, or who prays for 1 week time. List this matter after 1 week.
My lord. My lord.
May it please your lordship. On earlier occasion, we were allowed to take steps upon respondent number 4 by Dusty Modi, your lordship, which we could, we could have filed the affidavit today only, your lordship, which is not on record.
Yes, taken steps through the mode. Let it be brought on record. You have filed your affidavit. Heard Miss S. Mushahari, learned counsel for the appellant. Also heard Mr.
A Bhattacharjee.
A. Bhattacharjee appearing for respondent number 1. Learned counsel for the appellant submits that the appellant has already effected service of notice on respondent number 4 by the mode, and to that effect has also filed an affidavit in compliance today only. However, same is not on record. So, in view of the submissions made by learned counsel for the appellant, the registry is directed to place the affidavit in compliance filed by the appellant on record and list this matter in the next week on a date to be fixed by registry. Three forty-five. Mr. Goswami and Mr. Lal, how much time will you take?
10 minutes, sir. For myself, 10 minutes.
No, if you are going to take much time, we will not detain others. So be fair, because
He will take some time. Lord.
so other matters might not reach today. Mr. Mahanta. This is a part-heard matter. This is a part-heard matter.
Yes, no, in my matter is 43, 43. In this matter, my lord, they have to produce some record.
Report.
They have already withdrawn from the case. my lord. That's why they were asked to file on that. Your lordship, can you put on record that, my lord, then next course will be.
Okay.
Even
One order.
Because what happened in this case, my lord, I am the landlord, they are tenant, they are losing in both the court below. They filed this revision petition. Last 10 years, case is pending before this honorable court. They have not paid any rent before the court and anything, man. Nothing has been paid. That's why this honorable court asked them to file an affidavit. So they did not file an affidavit because probably
Mr. Goswami,
he has already.
we'll take your case after this matter. Small matter.
So they were asked to, they withdraw because they are. Your lordship, can you see last order, my lord? If it will be clear.
Yes.
May I please, Your Lordship? Lordship, we have handed over the brief to the petitioner, and on the previous occasion, Lordship, we were directed to produce the report of the consignment as well as the signature of the petitioner that they have received the brief. Here is the report.
What is the report?
Received the brief, Lordship. We have handed over the brief to the petitioner, and we were directed to
Produce any
produce the
document.
document that we have.
Intimation.
Then in such case, for what is the procedure?
Procedure, my lord, if normally, my lord, they have to issue register letter and that has to be produced, that consignment has, that acknowledgement has to be produced before.
Has been produced.
Now, that is they keep there, my lord, probably they knows it, my lord, even then, because they are not paying, that's why they are not going to file an affidavit. Court order, they cannot comply. Anyway, your lordship kindly keep them, keep it in record and fix it for next week for orders, and appropriate order will be passed.
Heard Miss
R. Hussain, Your Lordship.
R. Hussain, learned counsel, appearing for Mr. SCKR. You are for the petitioner. Learned counsel for the petitioner, who submits that the petitioner has already withdrawn, who submits that the engaged counsel for the petitioner has already returned the brief to the petitioner and has withdrawn from the case, withdrawn his wakalatnama. He submits, she further submits that in support of, no, the said information was also given to the petitioner by the engaged counsel by a registered post. Is registered post or speed post? By registered post. And in support of the said contention, the postal receipt of the letter posted by the counsel, Mr. Kaushik Jain, on 28/10/2025 to the petitioner, Shri Pankaj Duggar, has been produced before the court. Same is marked as X and placed in the record as a part of it. Learned counsel for the petitioner has further submitted that the brief of the case was also returned to the petitioner by the engaged counsel through registered post, and same has been delivered to the petitioner on 17/11/2025. And in support of her contention, she has submitted the postal track consignment report of the said consignment. The said track consignment. A copy of the said track consignment report, which is produced by the learned counsel, is marked as by and placed along with the report as a part of it. The learned counsel for the petitioner has also produced a letter dated 28/10/2025, whereby the engaged counsel has intimated to the petitioner regarding withdrawing from the case and returning of the brief. And in the said letter dated 28/10/2025, the petitioner Pawan Duggal, Pankaj Duggar has put his signatures in acknowledgement thereof. The said letter is marked as read and kept in the record of this case. Since it appears that the engaged counsel for the applicant, Mr. S.C. Kyal and Associates, the engaged counsel for the petitioner, Mr. S.C. Kyal and Associates, have withdrawn from the case of the withdrawn as engaged counsel for the petitioner. Their name may be struck out from the record. Their name need not to be reflected again in the cause list henceforth as engaged counsel. Let this matter be. Now, whether court has to issue notice?
In such case, not required, my lord. When they have
Yeah,
already informed,
yeah.
by this time they should have engaged, my lord, but like
Yes. We will give a
10 days time, after 10 days it will be listed. Because
yes,
we have already
sufficient time.
sufficient time, my lord.
So under such circumstances, let this case, under such circumstances, as it appears from record that the petitioner is aware about the withdrawal of his earlier set of engaged counsel from this case, let this case be listed again after 2 weeks, so as to give him an opportunity
My lord.
to engage a new set of counsel.
Okay, madam, no problem. But kindly that may be fixed, madam. Because it's a very old pending matter, last 10 years, my
Yes,
lord.
suggested.
First week of December.
5th of December.
My lord, no problem. Deeply.
Let this case be listed on 5th. আৰু কেইটা আছে?
Look, respect to item number 44. madam.
Yes.
Uh,
44 we may not,
Part-heard matter, my lord.
part-heard matter is
My
there.
lord, yes, my lord. That will be fixed in a date, in a hearing date, my lord. It's all pending case, my lord. Item 44.
January.
My lord, no, my lord. Until 9th of December. my lord. But it is for, by the claimant, my lord, they are not getting the money since 2000.
Lord Mr. P. Hajurika, learned counsel for the
Appellant.
appellant. None has appeared for the respondent. Let this matter be listed on
The hearing date,
18th of December,
18th,
on 18th of December.
my lord, apply.
Item
Yes.
48, 49.
Bejnat of Mataksan.
Maybe.
Today you will reply.
My reply will be there.
I'm taking a short break of 2 minutes. He is not on any other ground. Then the burden will shift on you.
Now, my lord, so for the point number 2 is concerned, my brother's contention is concerned, that policy was issued at 3:30 PM.
Yes.
Now, before issuing that particular certificate, Lordship may take note of my written statement.
Written
That-
statement where
My lord. Page number 13
of the
of the my brother's compilation. My lord.
compilation. 1-3.
1-3. Category.
You try to be as fast as possible because we have one more. Second part is also there.
Yes.
Yes.
I have enclosed the document. This is the first, the money receipt, my lord. In the statement. At
Yes.
page 18, my lord. Page 18, I will also got it. Now, in the same, my lord, money receipt, my lord, nowhere the insurance authority has stated and reflected the time when the premium was received.
Okay.
My lord. Now, the contention of our learned brother as to the fact that I paid the premium on 6/5/2005. So for the making payment of premium on 6/5/2008 has been admitted by the insurance authority. Now, it is the burden of the insurer at what time I have deposited the premium.
If they are going to take benefit.
Yes, my lord.
Okay.
Now, my lord, pleadings will, my lord, are very much necessary to be go through. Because when the evidence has been submitted in corroborating their written statement, my lord, nothing has been stated that at particular time I deposited the premium. Only evasive denial is there in their written statement that on the day of accident, my vehicle was not insured. The effective date of the policy as reflected in the policy document, my lord, that has been mentioned. And so for the other part, so what happened in between 6/5/2008 to 8/5/2008, that has not been mentioned. Why the effective date has been put on 8/5/2008, that ought to have been pleaded in their written statement. And that ought to have been proved by the insurance authority as to why, before putting the date, have not mentioned, intimated the amount of insured, even after receipt of the premium. At what time they have received the premium, that is not mentioned and pleaded and even proved.
Yes, one of his contention was that as you have put your signatures on the policy,
My lord. So
Even
for the
though-
putting my signature on the policy is concerned, but I'm going to that also. Now, when the policy has been signed by the insurance authority, at what place? On 6/5/2008, because they have put their signature on receipt of the premium. If you lordship go to their exhibit A,
Yes.
now, so far the issuance of that policy and getting the same on 3:30 PM, my lord. It is the printed part. If your lordship take note of the document, if the time as mentioned in the policy which I have relied upon and annexed with my written statement is tallied with the exhibit A submitted by the insurer, the date and time has been mentioned. Page 35 may go for my page 35. The same policy.
Yes.
The last part, my lord.
Yes.
12/6/2015 at 1:58 PM. If the two date and times are taken into consideration, it is the time when the document has been printed out. It is not the time when the document has been issued to me.
No, no. This year is different.
It is a 2015, my lord.
Accident
That
occurred on,
That means even I try to print out a copy of this policy, the today's date and time will be mentioned therein.
yes.
So this doesn't reflect that on that particular day, at that particular time, that policy has been issued.
Okay, okay, okay. You want to say that
The
when
time
the,
and date
when
mentioned in the
it
policy
indicates only time of taking out printout.
print out, not the issuance of policy.
Okay.
Now it is the burden of the insurer to show by producing the relevant records before the learned tribunal, my lord, that at this particular time, he deposited the premium and we accordingly issued the policy at this particular time. That is not here. So they cannot go beyond pleadings and beyond the point which has been asserted before the learned tribunal.
Okay.
Unless and until there is a proof regarding issuance of policy after the incident, it is always presumed that on that particular day, we have deposited the amount and covered the assured risk by the insurer.
Okay.
Contrary has to be proved. Now, second point, so far the second point as regards to time of issuance of policy is concerned, they failed. Even the ground and mentioned in the malab.
As regards time, there is neither a pleading nor proof. That is your submission.
Yes. So unless and until that is pleaded and proved, it cannot be presumed at the appellate stage that it was issued after the accident. Now, my lord, so for the first contention, as your lordship has pointed out, my brother has pointed out that the date of effective date has been mentioned on 8/5. Now, I want to show you lordship once again the premium receipt, my lord, page 18. Page 80.
Page 18,
My lord. This is the premium list.
yes.
My lord, serial policy number, the column. I will also got it, my lord.
Yes, which column?
Number 1, 2, 3. One
Yes.
is may taken into consideration, cash premium, 14,640. Bench. Now, the number which has been reflected therein is the policy number. Lordship may tell you with the policy number.
Okay,
That means on the day of receipt of the premium, they have issued the policy. It may not be dispatched to me on that day. So this policy number is reflected in the policy document. This number, this is the policy number. They have mentioned, it is their document, my lord. It is not my document. It is there in their custody and it is prepared by them and it has been supplied to me on receipt of the premium, that too in cash. Because had it been in check or otherwise, it will be always be subject to realization of that check. So since they have received the amount in cash and policy number has been given, except other than 6/5/2008, they cannot put other than without the consent and intimation to the insured person.
no, it only shows that
My lord,
so much of premium was paid in respect of so policy number on 6/5/2000.
serial number, policy number, I will
Okay.
also got it, my lord.
So against this policy number, this much of premium was paid
My lord.
on 6/5.
This policy number is also reflected in the policy document. I will also tell it with the next.
Yes, what you want to submit?
My submission is that on the day of submission and deposit of the premium for insuring my vehicle, they have issued a number, which is the policy number that is on from that day.
No, that they are not denying. On that day, they have issued policy number. They have also issued certificate of insurance.
Yes,
Their only submission is that it was issued at 3:30.
right.
So
is
that
the-
you have made submission.
In regards to that matter, I have submitted that it was not there, not pleaded, not true. Even not pleaded. My lord. Accordingly, my lord, from the day of receiving the premium, the liabilities of
okay.
insurance.
When in the policy, a stipulation was there that it will be effective from a future
ma'am.
date.
8.
And when you have signed the policy,
Yes.
the submission was that it was within your knowledge and therefore it is binding.
Yes.
You cannot claim the in
Yes.
cover before that date.
I could understand. Now, if the contention of the insurer is such that this, my lord, premium received is the amount for purchasing a policy, giving a future date, it is a proposal. Now, acceptance of proposal comes only when the policy has been signed.
No, that is not what I.
Unless and until, my lord. Unless and until.
His submission is that the contract is complete. Offer is there, acceptance is there, policy is also given, but with a stipulation that you can claim cover only after
8/5.
8/5.
I'm
And that was known to you.
going to that. On the day of receipt of the my lord premium, the authorized officer has put their signature on the day of receiving the premium.
Yes, that is also not denied.
That is not. Since their acceptance has been denied, my lord, putting a date
on 8/5/2008. Why it was on 8/5/2008, not on 6/5/2008?
Where is that clause 8/5/2008?
Until the policy effective date.
Page number?
Page number, my lord. 34, my lord.
Mm,
34 is the policy cover note, my lord.
Where is the date?
Period, my lord.
Effect date?
Effect date, my lord, period of insurance from 000 hours on 8/5/2008 to midnight 7/5/2009.
Yes, now their
Basing on this, my lord, basing on this, the insurance authority has claimed that they are not liable.
yes. And this was known to you also when
My lord.
you obtained the policy. My query is, when
yes, I
policy
could
was
understand.
given, you know that this is my cover.
Yes.
So you have to be cautious if you are driving vehicle outside that cover. That is his submission.
Yes.
How you will overcome this?
Lordship may take note. The page number 42, my lord. Page number 42. I want to show the date of issue of that document, my lord. The whole document and exhibit A. Exhibit A, my
Page number 42.
42. Date of issue 12 June 2015. Now, my lord, I again want to show page number 20. My lord. Here, my lord, the authorized officer has put his signature on 6/5/2008 in accepting the proposal of the insured, my lord.
On to page number
20.
okay.
Page number?
20, my lord. There is no 20.
Proposal. Okay, proposal.
Yes.
The moment they have put the signature on 6/5/2008, my lord, 8, my lord. Now here or any other document, there is no signature where I have put. My signature is not there, my lord. Either in exhibit A or this document. My signature was not there. Now, my lord, presuming that I have the policy and the date of effective date has been specifically mentioned in the first page, that it was on 8/5/2008.
Apart from first page, in the conditions, there is no mention from when it will be effective.
No, my lord. That was not mentioned. In the policy document, my lord, when it will be effective, only in the cover part, it was not mentioned in the condition column, my lord. So,
On what basis it has been mentioned?
my lord, now, my lord, it is the condition that when a proposal is going to be rejected or modified or terminated, then it has to be intimated to the insured, my lord, that under such and such circumstances, they are going to reject their, and the moment they have rejected my lord proposal, they ought to have returned my premium, my lord. Now, from 6/5/2008 to 8/5/2008, in between 2 days, it is not pleaded by the insurer, my lord, before the learned tribunal that during that period, what they have done as regards to my premium and proposal. Whether during that period, they are discussing about acceptance of my proposal or rejection of my proposal. And when they have accepted, it is not also mentioned that on 8/5/2008, my proposal has been accepted. It is not there. Nowhere it will find that.
No, so your submission is, because on this point, the counsel for claimant has already made submission. On this point also,
Yes,
your
my lord has already made a
your
submission.
submission is that from the date of acceptance of the proposal by the insurance company,
They're like,
they are liable.
Yeah.
They cannot put any other future date,
without giving me intimation.
intimation. That is your crux of submission. Okay. Okay.
Because they are bound to, my lord, intimate me to make any, before making any modification.
Okay.
Already my learned brother has already, my lord, submitted numbers of, my lord, judgments with me. I will not, my lord, burden your lordship.
I need to
Yes.
give a small. First thing, Lordship, this, their WSS file 4 years after the case had started, Lordship. So he knew very well. Now you can continue. So he knew very well what the case is because judgment was also passed against him on this particular point. So in his entire statement, we were saying that accident had occurred at 2:30, policy was not there. He could have very well said what time that he had paid the premium. Now it is for him to assert that we said that 2:30 accident occurred, policy was not in existence. Now when he comes to the 4 years, he knew the facts of the case. It's not that we both filed a year at the same time. He did not file, I filed it 3-4 years back when the case was given. So he could have, now even now he's not saying here they had given the premium at 2 p.m., 1:30 p.m., 1 p.m.
So your submission is burden is on him, not on the insurance.
He had the last say in this case. I did not file the second year. He did not mention that time even once that I had paid the premium at 1:30 and the policy. And there's a certain, I need to clarify certain yellow. One is this, the policy, there's never any intention of the insurance company to reject the policy. What is being said that from 6 to 8, why we did not cancel? Because we had never had any knowledge about the accident. Where is the question of rejecting it? Simple policy is the usual style. Someone comes, there's no record of previous insurance. He pays it. Normally insurance company keep it as safeguard. Okay, 2 days, they give an effect. They have 2 days, it would not have mattered much, but they give an effect because they can give an effect.
No, where is that clause?
What's it?
Clause in the policy that
No,
it will
I'm
be
not saying-
given.
I'm saying about the practice, Lordship. We are discussing why he said, why he was also trying to read my mind. I'm trying to reply that this is not there. Lordship, I'll just make it short. See, the document is one, Lordship. These are all computers, they come in one go, once. Premium, then policy, then all these documents are printed in one go. Nowhere it is always mentioned in already printed on 6/5. Lordship, his document that page number 21, he conveniently said this is the just date of issue is 6/5, the last page number 21, Lordship. That is his document. I have not given this document. He has given this document in which is written statement. And there also at the last line, 6/5/2008, 3:30. And it's all these documents in computer when this thing fed. This earlier people used to write in hand cover note, time is to mention. Then policy would be maybe when the type is not able, the policy would not be typed.
No, Mr.
No, this-
Goswami. I have heard that at 10.
Yes.
In the cover note of the insurance policy, the period of insurance has been mentioned
Yes, Lordship.
from 8/5
Yes,
to
that's perfect.
7/5. On what basis? Inside there is any stipulation in the policy?
No, basis means Lordship, that's it.
There, in the policy conditions, is it mentioned anywhere that the policy will,
The time in that's given in the policy itself.
where?
Effective date of commencement of insurance for the purpose of act. 85. 00 means 85 from the midnight of 85 to 75, 2009. Is there in para?
Okay,
This
okay.
Lordship is
Period
in
of
bold. It is there in bold.
Okay, okay.
Fourth line from the top, Lordship. 1, 2, 3, 4. Fourth line from the top, Lordship. There in the bold.
Okay.
Fourth line from the top. Effective date of commencement of further publish. No one can miss it.
Okay, then
It's
on this
printed in
point I have.
computer, printed in bold. And just the last line, date of issue 6/5, time is given 3:30. Lordship, he could have made a statement because he had the last say, last written statement to file. He had filed this Lordship claim petition. I have filed my written statement judgment. He comes. He could have made a very assertive way that I paid that premium at 2 p.m. or maybe 1 hour before that. No mention. He said he is taking advantage of the date. Date is that's the dispute. Your date is there, but whether on that date premium was paid before or after is the issue. And he had not met in his written statement. I have gone through the entire written statement. Not a single assertion that this premium was paid. In fact, before the accident had occurred.
Okay.
Burden lies heavily on him because he was the last voice
Okay.
in that particular yellow slip.
No further argument on
No,
this
my,
issue.
because my, before completion, my learned brother has started. Since my lord, I can my lord,
Your submission is that burden was on him.
because my lord, assertion is there.
No.
Assertion was there that.
If anything is
accident-
required, I will ask.
My-
Your submission is that burden was on his,